Hey, Thomas. We'll get started while they're making copies of the amendment.
Okay.
And we'll start with you.
What's that? We'll start with me?
Yeah.
Give me just a second.
Well, you're going to introduce your bill.
Yeah.
You got all that before you get the amendment. We got to do the pledge, the prayer, all that good stuff. Does that work?
You just said that.
Jason, can you get that ready quickly? I'll talk to you in a second. We'll get started. Committee will come to order. The committee will come to order without objection. The chair is authorized to declare recess anytime pursuant to Committee Rule 2, House Rule 11, Clause 2. The chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. Now recognize the gentleman from Wisconsin, Mr. Fitzgerald, to lead us in the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Pursuant to notice, I call up H.R. 6824, the NICS Data Reporting Act, for purposes of markup, and move that the committee reported favorably to the House. The clerk will report the bill.
H.R. 6824 to require.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from, I know Mr. Massey and Ms. Jackson-Lee have worked on this legislation. The chair recognizes Mr. Massey, the sponsor of the bill, for an opening statement.
Thank you, Mr. Chairman. H.R. 6824, the NICS Data Reporting Act, is a simple and straightforward piece of legislation that many colleagues on both sides of the aisle have supported in the past. In fact, this legislation was part of a gun bill that the Democrats passed when they were in the majority. They were so kind as to allow this to be included. It simply requires the Attorney General to submit to Congress a report that includes the demographic data of the individuals determined to be ineligible to purchase a firearm based on a background check performed by the National Instant Criminal Background Check System. During the last Congress, I offered this as an amendment to H.R. 7910, a bill introduced by our colleague, Ranking Member Nadler. Then Chairman Nadler accepted the language at markup of that bill, which went on to pass the House. According to FBI's report on federal denials, as of 2024, there have been over 2 million individuals denied access to a firearm after a NICS background check system. However, there have been nowhere near 2 million prosecutions of individuals for lying on their Form 4473, which is the form that potential firearms purchasers complete for their background check. In fact, the number of prosecutions is very low. There were 12 cases that were successfully prosecuted in 1 year out of the millions of denials. So one question is, why is the Department of Justice not prosecuting these crimes? And the answer is, look, a lot of these, most of these are false positives. And we want to know why they were falsely denied. One concern that I have here, and research has shown this is actually a fact, is that they're sloppy at the NICS, in the NICS check, in a way that deprives disproportionately American citizens of their right to own a firearm. For instance, within they use phonetically similar spellings of names to do the background check, and they use not exact birthdays, but similar birthdays. If you were applying for a job at a bank and they were this sloppy with their background check system, the people doing the background check system or the bank who was hiring people would be sued out of existence. Because here's the problem at NICS that our research has shown. People within ethnic and racial groups share similar names. So if you're Hispanic, you're likely to have a name that's similar to somebody else's who is Hispanic. If you're Black, you're more likely to share a name with somebody else who is Black. Now, what happens, and the data will show this, and that's why we have to get the data, is that if you're a Black male and you go to purchase a firearm and you're a law-abiding citizen, never committed a crime, have no disqualifying aspect, and they do a background check system on you, you're 3 times as likely to be denied, falsely denied, the purchase of a firearm, because you are likely to have a false positive, a false match with somebody who has a disqualifying condition. For instance, somebody who's been convicted of a crime that's punishable by a year or more in prison. And if you are Hispanic, we suspect that the false denial rate is twice for Hispanic males, that it's twice what it would be for Caucasian males. And this is problematic. I mean, regardless of how you feel about the background check system, it needs to be accurate, and it can't be inaccurate in a way that's racially prejudicial. So that's, I mean, this is basically a very simple bill. It's a reporting bill. I've asked the FBI director in our hearings to give us this data. They say they would give it to us, and they haven't. For years, I've been asking for this data. They haven't been giving it to us. It's time to pass a law to get this data, and I appreciate the bipartisan support we've had on this in the past. Yield back.
Gentleman yields back. We appreciate the gentleman's leadership on this as well as the ranking member. Now recognize the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, this legislation would require the Attorney General to submit an annual report to Congress providing the demographic data of those who failed the National Instant Criminal Background Check as part of an attempted firearm purchase in the preceding year. The National Instant Criminal Background Check System, or NICS, has processed more than 300 million checks since the FBI launched the system in 1998. NICS checks are critical to enforcing our laws that prohibit certain individuals from possessing a firearm. The overwhelming majority of NICS checks determine that the prospective purchaser may legally purchase a firearm, and these checks are typically completed in just a few minutes. This means that there is little to no imposition on the rights of responsible gun owners. But in some instances, a NICS search determines that a person may not legally purchase a firearm because the person is matched to a serious criminal conviction, a domestic violence restraining order, a dishonorable discharge from the armed forces, a wanted persons list, or other disqualifying record. Since its inception, NICS has denied sales in 1.5 million transactions, keeping millions of firearms out of the hands of those who should not have them. Congressman Massey first brought this reporting requirement when we approved it as an amendment to the Protecting Our Kids Act, a gun violence prevention package that we marked up last Congress. At that time, he argued that it would shed light on those who are falsely denied by NICS. He argued that Black and Hispanic men were especially likely to experience false denials since, due to over-incarceration, they are disproportionately likely to share a name with a Black or Hispanic man who is incarcerated. The FBI, which operates NICS, has multiple processes available to address the possibility of false denial. When a person receives a denial, he or she may use an online system to quickly file a free appeal, which will also inform the person of the reason for the denial. The FBI has also established a system specifically for those who experience delays or repeated denials that they believe are in error, which could be due to having a name similar to a person who is prohibited from purchasing firearms. By using the voluntary appeal file process, a person can have his or her case reviewed by the FBI. FBI staff can then confirm that the person may legally purchase firearms and then issue a unique personal identification number, which can be used to ensure accuracy and efficiency in future background checks. These procedures are in addition to the use of other demographic information, like date of birth and the optional provision of a Social Security number, which reduces the instances of false denials due to name overlap or other reasons. In 2022, more than 31 million NICS checks were conducted. Of these checks, just 0.07%, 7 out of 10,000, were denials that were appealed, and just 0.02%, 2 in 10,000, were denials that were appealed and then overturned. The overwhelming majority of NICS denials are the result of the system working as it should, keeping guns out of the hands of those who are prohibited from having them. Given the importance of NICS, we must continue to make sure that it is a trustworthy system that does not burden lawful gun owners with false denials, and critically, does not mistakenly allow gun sales to those who are prohibited from having firearms and may harm our communities. That is why I've repeatedly supported efforts to improve the records in NICS through legislation and targeted grants. I hope our colleagues will continue to work with us on future efforts to ensure the accuracy of NICS to keep all of us safer. I thank Congressman Massey for working with our staff on a bipartisan basis to improve his bill by ensuring that the demographic reporting it would require also includes the reason for such denials. This will help us have a fuller understanding of not only who is denied, but why. The modification will make the bill even stronger than when we approved it last Congress as an amendment to the Protecting Our Kids Act. I hope this legislation will continue our understanding of the functioning of NICS so that we can continue to improve it. I am pleased to support the bill, and I urge my colleagues to support it as well. Before I yield back, I must also note that yesterday was the anniversary of the shooting that killed 17 people and injured 17 more at Marjorie Stoneman Douglas High School in Parkland, Florida. Yesterday also marked the 48th mass shooting just this year so far, as one or more people opened fire in a crowd of thousands gathered to celebrate Kansas City's Super Bowl win. Lisa Lopez Galvin, a local DJ, wife and mother of 2, has died. 21 others were shot, including 9 children. In the last Congress, under Democratic control, this committee advanced many bills that would reduce gun violence and save lives, including the Protecting Our Kids Act, the Assault Weapons Ban, and the Federal Extreme Risk Protection Order Act. Each of those went on to receive bipartisan support on the House floor. We also passed the Bipartisan Safer Communities Act, the first gun violence prevention legislation to become law in decades. But in this Congress, under Republican control, this committee has not advanced a single bill to prevent gun violence. The Republican leadership has not allowed a single vote that will prevent losses of life like those that occurred in Parkland, in Kansas City, or in countless other cities. Democrats continue to offer solutions, but our colleagues continue to block us from making Americans safer. Nearly 50,000 Americans have died by firearm since Republicans took control of the House. The events that took place yesterday did not change anything about the agenda for this markup, but we cannot let them go unnoticed. They are a reminder that every day of inaction costs the lives of more Americans. I call on my Republican colleagues to join us in our effort to end gun violence. Thank you, and I yield back.
Gentleman yields back. Chair now, without objection, all other opening statements will be included in the record. The chair now recognizes the gentlelady from Texas who has worked closely with Congressman Massey on this legislation.
Let me thank the chairman and ranking member. This is an important matter for recognizing the need to be precise and protect the rights of those impacted by data collection. I'd like to echo the words of ranking member and express my deep sadness for the people of Kansas City. We must take action to prevent gun violence and end the senseless tragedies our communities continue to face. I think it should be well noted that yesterday was, of course, the 6th anniversary of the Parkland shooting, and as well to recognize that at least 12 children were hospitalized in Kansas City for being wounded by gunfire. I don't think this nation can continue to go to this pathway, and I would ask the chairman of this committee for us to come back to have a session that particularly goes over our gun bills, marks them up, and send them to the floor of the House. People are asking how much more can they take with the violence, gun violence here in this nation. It is too early to know whether a background check, safe storage, a ban on assault weapons, or some other solution might have prevented this tragedy. but we do know that gun violence is preventable. We also know, as I indicated, that the American people are begging for gun violence to be stopped. We know there are actions that we can and should take to make our community safer and to implore our colleagues to join us in that work. I also agree with the ranking member's remarks on this legislation. We must make sure that the National Instant Criminal Background Check system is both effective and equitable. NICS is a critical law enforcement tool that brings together millions of records from a wide variety of sources. This system allows for state and federal NICS staff to quickly determine if an individual may lawfully purchase a firearm or not. The need for accuracy in this system is obvious. An erroneous denial can result in a person having to take extra steps, causing a delay in their ability to purchase a firearm. On the other hand, an erroneous approval can result in a gun being sold to someone who cannot legally have one and might cause harm to themselves or others. When erroneous sales are discovered, law enforcement must follow up to retrieve the firearm, creating a potentially dangerous interaction. Guns kill, and guns in the hands of people who are here to do harm or have other reasons kill, and they kill over and over again. And that's what we're seeing in the mass shootings. I think we may be up to 47, and this year, 2024, of mass shootings. Thankfully, both types of errors are rare, yet we must continue to monitor the effectiveness of NICS and seek continual improvement. NICS depends on collaboration across local, state, and federal partners, and Congress must continue to support that collaboration so that all entities are entering accurate records into the system. When Congressman Massey raised this reporting requirement as an amendment to the Protecting Our Kids Act last Congress, he spoke about the harms of overcriminalization. I was glad to work with him. He expressed his concern that Black and Hispanic men might face an increased rate of false denials since they may be most likely to share a name with a person who is incarcerated. Unfortunately, something we have to stop as well. I appreciate his concern about the burdens of overcriminalization places on Black and Hispanic people, often requiring law-abiding citizens to go above and beyond to prove they are not a threat. This is an unfortunate reality and one that we don't always hear acknowledged by all of our colleagues. And so appreciation to him for that analysis. While this bill might help us learn more about NICS, it will unfortunately not address the daily harms that law-abiding people of color experience in their interactions with our criminal justice system. But my door is always open to any of my colleagues on this committee and in the Congress who are willing to work on addressing these challenging problems. And while this legislation may not address this particular issue, it could still improve our understanding of NICS and ensure that it is an effective and equitable tool to make our communities safer. For that reason, I support this legislation, and I urge my colleagues to support it as well. And Mr. Chairman, I thank you, and I yield back.
Gentlelady yields back. For what purposes the gentleman from Kentucky seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
An amendment to H.R. 6824 offered by
Without
Mr.
objection, the
Massey.
amendment will be considered as read. The gentleman from Kentucky is recognized to explain his amendment.
The amendment's very simple. In fact, it includes includes language that the Democrats asked me to include in this bill, and I think they had good ideas, so we put them in this amendment. The amendment also just clarifies what it is that the FBI is going to have to give to us in this report, and because we want it to be complete. We want to know things, for instance, like if you were denied a firearm and through the NICS background check system, and then you applied for an appeal, what was the success rate? Is there a racial disparity in the appeals process? And that's something that we're concerned about. I want to thank Ms. Jackson Lee for being consistent on this issue. We shouldn't have racial disparities in drug prosecutions. As AI technology develops, we want to make sure there's no racial disparities in that. We've talked about facial recognition in the Oversight Committee and how we need to make sure there's no racial disparities there. And Ms. Jackson Lee has been consistent in that, in her pursuit of equality under the law. And I appreciate her consistency in supporting this as well. It's a genuine concern. There's no gotchas here in the bill and no gotchas in the amendment. And I think it'll shed some light and cause us to be able to improve the system in a way that's more fair than currently is. And I just, real quickly, last Congress, there were some conservatives who opposed this amendment because it calls for reporting of sex and gender, both. And they thought that my bill suggested that sex and gender are two different things. The reality is the ATF on Form 4473, they once used to ask for sex, and now they ask for gender, or vice versa. So we have to ask for both sex and gender on this. This isn't some woke ideology that's crept its way into my to my law here that I'm trying to pass. It's basically just the reality of the 4473 and how they've asked the question differently over time. One other thing I want to clarify, the demographic data will include race, ethnicity, national origin, sex, gender, age, disability, and English language proficiency of the applicant, but these won't be identifiable. They will not identify individuals. The reports that we're asking will protect the privacy of everybody who has undergone the background check system. We're not trying to identify these people individually. We want to know statistically. So those things will not be revealed. The individuals won't be revealed through that data. And so there will be no privacy infringement on this. Again, I think the amendment that I've offered here needs to be adopted. One of the things also that I added in the amendment is we want to know the demographic data of the people who were approved. Because if we're going to establish a rate of disapproval, we have to have a denominator. And in the first bill that I offered that the Democrats generously accepted last Congress, we just sort of trusted that the FBI would give us that number, and I want to be clear in the amendment that they need to tell us not just the demographics of the people who were denied, but of those who were approved, so that we can establish a baseline and know in order to know if there's a disparity in terms of percentage. And with that, I yield back.
Mr. Chairman.
The gentleman yields back. Go to the ranking member, then we'll go to Ms. Drivey.
Mr. Chairman, I find myself perplexed for the second day in a row. I find myself in total agreement with Mr. Massey. It's a good amendment. I support the amendment. And I think from long knowledge of Mr. Massey, I can assure everyone that there is no woke ideology in this amendment. So I urge the amendment, and I yield back.
Gentleman yields back. The gentleman from Maryland is recognized. Then I'll come to Sheila.
Thank you, Mr. Chairman. I appreciate that. To Mr. Massey, I appreciate this language. I'm inclined to support it. I did have a question. But before I get to that, I did want to suggest a couple of things. I think the points you made about potential for confusing names. When I was a prosecutor, one of the things we ran into was confusion of surnames with respect to in the Latino community, because sometimes just culturally they did it differently than the people who were checking documents. It wasn't necessarily just the NICS check, but just some of when we were trying to make sure we had the right people that matched up with the fingerprints. So that might be one of the factors as well. The other one I ran into was identity theft. Brother or cousin giving somebody else's name and it not getting cleared up. I don't know if that's a factor here, but that would certainly be something I'd be interested in finding out, because we do want to try and correct that kind of inaccurate information. I did also want to suggest, along the lines of what the ranking member said and Ms. Jackson-Lee, about sort of some of the broader issues that we should take a look at. Now, we're not going to do it today, and I get that, but the background check piece, and I might be behind on this, but the Lakewood shooting, one of the things I read in the paper, and that was overtaken by Kansas City, sadly, but that the woman who was the shooter in that case had been red flagged, or the gun had been seized or something in a court proceeding just a few years earlier. So one of the questions I came away with was, well, how did she get another gun? And that might have been answered, I might have missed it, but those are the types of things that I would love to see if we could review in the committee or even in the subcommittee. I'm not on the subcommittee, but I would love to come sit in because I think those are critical issues. And others, ghost guns and the like, I'd love to see us try and take some of that on as well. With respect to this language, though, English language proficiency, I was sort of curious as to what the goal is there in seeking that information, and also how are they going to determine that? Is that something where they're sort of self-selected by the person filling out the form, or does somebody make an evaluation about it? How does that work? And I yield to the gentleman.
I'm not sure if it's on the form 4473 or not. If somebody on the staff could look at that to see if they choose that. But one of the concerns that I have there is it harder for you to navigate the legal system based on English language proficiency? Let's say you're denied, and then you're trying to do an appeal, and if how well do you fare in that appeal? By the way, the first appeal is easy, and it's almost de facto and granted to you. But after that appeal, you go into the legal system, and I know I've used this argument before in judiciary, and it doesn't get much traction because 90% of the people here are lawyers. But after that first appeal, you got to hire a lawyer and pay money, and which I know isn't a problem for the lawyers on this dais. But what I'm concerned about is the appeals process, and is it going to be harder for somebody without English language proficiency?
I thank the gentleman, and I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Texas, Mr. Roy.
I just wanted to thank my friend from Kentucky, the gentlelady from Texas, and those working on this legislation. I agree with the legislation. I also want to point out to the ranking member that I agree. This is 2 days in a row. I told you last night walking off the floor I would try not to make it too often, but here we are again agreeing. I hope we can continue, by the way, as a side note, to move forward with the judiciary product on FISA. I know that's not what we're here to talk about, but it's something that we should do. This committee did great work on that product. It should be the product that's being brought to the floor of the House, and we should do it immediately. And I hope that that's what the will of the body will be able to carry it forward with. I did want to say one thing with respect to something my friend from Kentucky alluded to, concerns, I think he said, for some of our Republican colleagues on the question of sex and gender and ideology, woke ideology, whatever. I think he's made that clear, so hopefully that will clear up any confusion if people are voting on this in committee or on the floor, should we get there. But I also want to note, because I think it's important, that just by virtue of us wanting to work on this issue to collect data, I know my friend from Kentucky and his view of the Second Amendment and the view of ensuring that there's not burdensome systems that interfere with the right to defend ourselves and so forth. We have differences of opinion across the committee on how to have NICS operate and so forth. But that at the end of the day, the goal, I know, of the gentleman from Kentucky, like mine, is to ensure that we're protecting Second Amendment rights and doing so equally, and that nobody should be denied their ability to defend themselves under their constitutional right to defend themselves based on race or based on any other factor. And that I assume, and I'll yield to the gentleman from Kentucky, I assume that he is motivated by that to ensure that we're able to have all Americans, regardless of their background, their color, their ethnicity, their name, get equal access to be able to afford themselves protection under the Second Amendment of the Constitution. I'd yield to the gentleman from Kentucky.
Absolutely. I think everybody here recognizes our Second Amendment. There are legitimate reasons for possessing a firearm, and we wouldn't want to deprive anybody based on their race or gender or national origin the ability to exercise that amendment. But we may want to exclude them based on felony convictions, and that is what this does. If they're violent criminal, that's what the background check system is about. We just don't want to mix those two categories of people carelessly in a way that disproportionately affects a certain segment of society. And that's what my concern is that's going on, and research indicates that, and I'm just trying to get that data. And if we have that data, we shouldn't be afraid to see it, and it may be disappointing when we get it, and then we need to figure out how to fix it. Because if you, like I said before, if you were a private employer and you had a system, let's say you're a bank and you do a background check on everybody, and you had a system that was racially prejudicial, a background check system, you'd probably get sued out of existence once it got discovered. But that's not the case with the government, you know. And so it's up to us here in Congress. If there's a disparity in a government system, it's up to us to fix it. And to fix it, we got to know how pervasive it is. So, yes.
I think John from Kentucky, and I'll move along, but I just finally say, when I was a prosecutor, and it wasn't for a long period of time, but when I was doing prosecutions under Project Safe Neighborhoods. And so we were constantly working to ensure that we were, had good data and understood what was going on. But prosecuting and putting people in jail for misuse of firearms was what I was doing. And we want to make sure we've got the right data. We want to make sure that we're able to prevent it if you've got felons. And then, but I would just note here on the back end of that, we need to continue to make sure the Department of Justice is prosecuting on the backside of that when you have felons that are using firearms. And I think that's something we need to continue to press on from an oversight perspective with the Department of Justice to ensure they're doing that. I'd yield my remaining time to the gentleman from Kentucky.
Yeah, I just want to answer Mr. Ivey's question more thoroughly. I've got the 4473. It doesn't ask for English language proficiency, but the text of the amendment says if available. So if it's available, we want the FBI to report that to us, but it's not a new mandate to report that.
Yield back.
Gentleman yields back. The gentlelady from Texas is recognized. Speak on the amendment.
I think this tranquil discourse is overwhelming in its spirit and its emotion. And my good friend, Brother Chip, it looks like we'll find some time to travel through the tulips of Texas when we get back home. And I thank him. I'd like to do FISA as well, so maybe we'll have some opportunity to do that. We in the judiciary work very hard on it. I want to put the underpinnings to both the chairman and the ranking member of what this is. Congressman Massey and I appreciate it. It is to avoid discrimination, and I think that's what we should emphasize. And I hope with the oversight of the Judiciary Committee, we'll be very attentive to make sure that it doesn't do the reverse, that it doesn't discriminate against black and brown. And what Mr. Massey and I came to a conclusion, and I'm grateful for the collaboration, is that it's unfortunate, but by history or by culture or by circumstances, maybe I should say, black and brown men have records, or black and brown people have records. We got to the over-incarceration too late. We're trying to stop it now. And so with that in mind, they would have a tendency to have similar names and be blocked from their constitutional right. So we're trying to enhance constitutional rights by trying to find out, is there any discrimination on names and age and other things dealing with individuals who happen to be of that background. So your good faith is appreciated. I hope that we can continue to do this kind of work. Your amendment is one that we were willing to accept. Thank you for working with our staff to ensure that due process is included. That's one of the issues that I wanted to emphasize. And I wanted to also emphasize that there is sufficient data to indicate that there's discrimination. But I will also say that maybe we can keep working and find some common ground that doesn't offend gun owners, which I never want to offend since my state is 110% gun owners, to find a way. It would be good, Mr. Massey, for two of us to look at the storage bill, but to look at ways to stop the proliferation of guns in the hands of bad people, which is what we all have said, which generates the unfortunate results. We don't have the final determination of yesterday. Something went wrong, and somebody had a gun that should not have had a gun. So I want to just end my remarks by saying we did a fine job a year or two ago on the George Floyd Justice and Policing Act. And it was bipartisan, and there might be somebody swallowing hard on the other side right now, but I think we have ways of looking at that legislation, looking at other legislation, and doing good things for the criminal justice system. And this adds dignity to the criminal justice system, it adds due process, and it adds fairness. So I want to, again, thank my partner in doing this and ask that we support the amendment and the underlying legislation. With that, I yield back, and Mr. Chairman, you know I'm going to say H.R. 30, the human trafficking bill, has the same kind of potential for us to work together as well. Thank you.
Gentlelady yields back. The question occurs on the amendment from the gentleman from Kentucky. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chairs, the ayes have it. The amendment is adopted. A reporting quorum being present, the question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes. Oh, the gentleman from Florida asked for a recorded vote. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa?
Okay, what's our next one?
Mr. Buck? Mr. Gates? Mr. Gates votes yes. Mr. Biggs? Mr. Biggs votes yes. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Spartz? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Klein? Mr. Armstrong? Mr. Armstrong votes yes. Mr. Gooden? Mr. Gooden votes yes. Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Mr. Moran? Mr. Moran votes aye. Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Fry? Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson? Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye.
The gentleman from California, Mr. Issa?
Mr. Issa, you are not recorded. Mr. Issa votes yes.
Are there any members who wish to vote who haven't been recorded? Yeah, I think we are too. Clerk will report.
Mr. Chairman, there are 26 ayes and 0 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 7322, the Standing Up to the Executive Branch for Immigration Enforcement Act for purposes of a markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 7322 to amend the Immigration and Nationality
Without
Act.
objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from North Carolina, the sponsor of the legislation, Mr. Bishop, for an opening statement.
Thank you, Mr. Chairman. Thanks also to the gentleman from Texas, Chip Roy, for joining me as co-sponsor. This bill should enjoy bipartisan support in the interest of vindicating the rule of law, the constitutional role of the Congress, and the avoidance of inter-branch conflict. In United States versus Texas last June, the Supreme Court held that state attorneys general lack standing to sue the Department of Homeland Security when the department adopts operating practices that violate, in fact, explicitly and directly contradict statutory commands of the Congress. There, the issue was detention mandates, statutes that command the Secretary to detain until removal certain criminal aliens having been convicted and incarcerated for listed crimes or aggravated felonies and terroristic activity having been released from state custody, and also aliens subject to final orders of removal. The Secretary, you see, had issued guidelines saying those factors would never alone be sufficient to cause the detention of any person. What Congress had mandated, the Secretary of Homeland Security simply countermandated. The Federal District Court and the Court of Appeals found that the Secretary's guidelines violated specific detention mandates, and furthermore, that the Secretary did that while underutilizing detention space and repeatedly asking Congress to provide less detention space resources. The Supreme Court didn't disagree with any of those findings. It simply said that because the executive retains some prosecutorial discretion, even under Congress's statutory mandates, the court could not put itself in the position to referee whether in a particular case the executive was in fact exercising prosecutorial discretion or flouting acts of Congress in favor of a different regime of its own choosing. In other words, rule of law or rule of man. The court observed that such disputes generally must be left to resolution between the Congress and the executive, that if Congress wants its laws to be followed, it must impeach or cut off funding or other drastic actions, almost all of which have undesirable collateral effects, which Justice Alito characterized as Congress going to war with the executive. We've done that just this week in the articles of impeachment against Alejandro Mayorkas, only the second cabinet officer ever to be impeached. Many members of the minority, in fact of the majority, commented that this is an unsatisfactory state of affairs. Everyone should agree with that, but it is not acceptable to allow the executive to ignore Congress's laws at will. Now, in United States versus Texas, the concurrence of Justice Kavanaugh pointed to a path that might avoid the constitutional conflict between the Congress and the executive. He said, in holding that Texas and Louisiana lack standing, we do not suggest that federal courts may never entertain cases involving the executive branch's alleged failure to make more arrests or bring more prosecutions. And then skipping, as the Solicitor General points out, that's the Biden administration Solicitor General. As the Solicitor General points out, the standing analysis might differ when Congress elevates de facto injuries to the status of legally cognizable injuries redressable by a federal court. For example, Congress might specifically authorize suits against the executive branch by a defined set of plaintiffs who have suffered concrete harms from executive under-enforcement, and specifically authorize the judiciary to enter appropriate orders requiring additional arrests or prosecutions by the executive branch. And he went on to say that in these cases, the relevant statutes do not supply such specific authorization. This bill, now before the committee, does that in an appropriately balanced way. It specifically authorizes suits against the executive branch by a narrowly defined set of plaintiffs, state attorneys general, and authorizes the judiciary to enter appropriate orders. This language is added to detention, parole, and visa sanction provisions where Congress has commanded certain actions from the executive. Courts still have room in every case to examine whether particular executive branch decisions are bona fide exercise of discretion or attempts categorically to change the law in defiance of Congress. Finally, this is extremely timely. Just this week, the 11th Circuit sent back to district courts in Florida other immigration cases brought by state attorneys general to be reconsidered as to whether those courts had jurisdiction because of the standing issue. There, the issue was not the Department of Homeland Security's categorical refusal to take certain aliens into custody per Congress's mandate, but the categorical release of migrants already in DHS custody into the interior via the Alternatives to Detention program, replete with ankle bracelets and cell phones. So the issue is, should we facilitate correction of the executive branch overreaches of authority by means short of drastic constitutional conflict? To ask the question is to answer it. Attorneys general have asked for this, and certainly we want to afford the opportunity to seek relief from courts on behalf of their states that's when they suffer specifically concentrated injuries. And I believe those in the minority may want this in the next administration. So I urge the committee favorably to consider this bill, Mr. Chairman, and with that, I yield back.
Gentleman yields back. The chair now recognizes the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, after a string of setbacks for conservative governors in which courts have properly found that states have no standing to sue the federal government over certain immigration policies, Republicans are attempting to invent grounds for standing where plainly none exists. H.R. 7322 purports to provide state attorneys general legal standing to sue the federal government in federal court for alleged harms resulting from, in their view, violations of the detention and removal via discontinuation and parole requirements set forth in the Immigration and Nationality Act. This legislation is, practically speaking, a pointless gimmick. Succinctly put, Congress cannot simply grant the plaintiff legal standing through legislation where the plaintiff cannot prove that it meets the Supreme Court standing requirements under Article 3 of the Constitution. Ultimately, it's the judicial branch, not Congress, that will determine whether the plaintiffs meet those requirements. This is because the Supreme Court has repeatedly stated that standing is a bedrock constitutional requirement and is built upon the separation of powers. The Court has emphasized the standing doctrine acts as a safeguard for the limited role of the judicial branch in our system of government by preventing the judicial process from being used to usurp the powers of the political branches. Yet that seems to be precisely the intent behind H.R. 7322. Following the lead of former President Trump, MAGA Republicans sabotaged an attempted compromise on border and immigration policy through the political process. Now they want to pass a bill to see if state attorneys general can convince the judicial branch to impose the draconian immigration policy preferences that MAGA Republicans have failed to get through the political branches of the state government. The bill simply declares that states have standing to sue so long as the state or its residents suffer almost any degree of harm, no matter how trivial, appearing only to exclude financial harms that are less than $100. But just because this bill declares that there is standing, it does not make it so. Congress cannot, by statute alone, elevate nearly every de facto injury, if any, that may result from the executive branch's exercise of discretion in immigration enforcement matters to meet the requirements of Article 3 standing. Article 3 of the Constitution vests the judicial branch, not Congress, with the judicial power of the United States, but it also specifies that this power extends only to cases and controversies. The Supreme Court has interpreted Article 3 to limit the jurisdiction of federal courts only to cases and controversies where plaintiffs have demonstrated that they have suffered an injury in fact caused by the defendant's conduct that is being challenged before the court, and that the injury is likely to be redressed by a court order. Congress cannot ignore these requirements and simply deem nearly every so-called injury that a state or its residents might incur is sufficient to support standing. Moreover, incurring an injury is not enough. The injury must also be legally and judicially cognizable, which the Supreme Court has explained requires that the dispute or controversy be of the kind traditionally thought capable of resolution through the judicial process. In summary, Congress cannot simply declare that standing exists for the attorney generals to sue on behalf of the states. Standing either exists in a given case because it presents a case of controversy cognizable in the meaning of the Supreme Court use of the term, or it does not. If it does, the state attorney general may sue now. If it does not, this bill will not help. This requirement is particularly salient in the immigration context. So either this bill is unnecessary or ineffective. This requirement is particularly salient in the immigration context. Just last year, the Supreme Court addressed the issue of state standing to sue the federal government over immigration enforcement matters, which this bill appears to be a half-baked attempt to circumvent. In U.S. versus Texas, an 8-1 decision, the court held that Texas and Louisiana lacked Article 3 standing to bring suit against the federal government over its alleged violation of some of the very same immigration statutes that this bill would purport to grant standing to the states to sue over. In rejecting the state's standing argument, the court noted, among other things, that lawsuits alleging insufficient arrest or prosecution run against the executive branch's Article 2 authority to enforce the law, which includes the discretion to determine enforcement priorities in the face of lack of resources and shifting public safety and public welfare needs. In short, it is not enough for this legislation to state that nearly every harm that is incurred is sufficient for standing. The courts traditionally have not redressed injuries involving allegations that the federal government's lack of arrests or detentions harmed a plaintiff. That is because courts are ill-equipped to consider the questions that would be necessary to craft a judicial remedy in a hypothetical legal action authorized by this legislation. Additionally, any judicial remedy would run headlong into the executive branch's constitutional authority to exercise prosecutorial discretion and to determine policy on matters related to immigration and foreign policy. These are the exact separation of powers issues that the court's standing doctrine is meant to avoid. My Republican colleagues appear to have given up hope on any of their ill-conceived immigration bills becoming law this Congress, and they are now instead trying to empower their counterparts in states' attorneys' general offices to legislate through the courts. And we can tell that they are running in circles because they keep coming back to the same partisan talking points. The provisions of the Immigration and Nationality Act, for which they want to manufacture standing, align with the Republicans', quote, grounds for their sham impeachment of Secretary Mayorkas this week. Despite the fact that the Biden administration's actions on parole, detention, removal, and sanctions are in line with decades of precedent by administrations of both parties, my colleagues want to claim that they are violating the law. But in reality, the Biden administration is doing all it can in the face of our broken immigration system. The administration tried to fix it. They negotiated the toughest, most enforcement-heavy bipartisan immigration reform bill we've seen in years with conservative Republicans, but then the Republicans changed course after Donald Trump told them to and killed the bill. They're not interested in solving these problems. They would rather have more chaos at the border and a campaign issue, and have hand-picked judges elevate their policy disagreements as legitimate arguments to bolster their party in an election year. H.R. 7322 is a pointless, ill-conceived gimmick that will not accomplish its goal because you cannot create standing where it doesn't exist. The courts will determine standing in each particular case. So it fails to even to accomplish its goal. I urge my colleagues to reject it, and I yield back.
Gentleman yields back without objection. All other opening statements be included in the record. The chair now recognizes the gentleman from North Carolina for the purpose of offering an amendment in the nature of a substitute.
I have an amendment in the nature of the substitute at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 7322.
Without objection, the amendment in the nature of substitute be considered as read and shall be considered base text for the purposes of amendment. The chair recognizes the gentleman from North Carolina to explain the amendment.
There's nothing significantly different in the text of the amendment in the nature of substitute. And with that, Mr. Chairman, I yield back.
Is there any discussion on the amendment in the nature of a substitute?
I have an amendment at the desk. I have an amendment at the desk, Mr. Chairman.
Clerk will report the amendment. Gentleman reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7322 offered by Mr. Nadler. Page 2, line 14, and all that follows through page 3, line 13, and redesignate
Without
this.
objection, the amendment be considered as read. The chair recognizes the gentleman from New York, the ranking member, to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, my amendment would simply strike sections 2B and 2E of the bill. These provisions purport to grant standing to state attorneys general or other authorized state officials to bring an action against the Secretary of Homeland Security for supposed harms to the state or its residents arising from their actions to enforce certain immigration law provisions. The bill requires the court also to consider such a lawsuit to expedite the bill also requires the court considering such a lawsuit to expedite consideration and disposition of the case to the greatest extent practicable. Finally, it deems the state or its residents to have been harmed if the state or its residents experience harm, including financial harm, in excess of just $100. Sections 2B and 2E would add this standing language to sections 236 and 241A2 of the Immigration and Nationality Act, which govern the detention of non-citizens. When one cuts through all the verbiage of these provisions, one can see them for what they really are: a pointless smoke and mirrors attempt by the bill supporters to circumvent Article 3's constitutional standing requirements and to upend the constitutional order when it comes to immigration enforcement. As I outlined in detail in my opening statement, the Supreme Court has already made abundantly clear in U.S. versus Texas that states lack Article III standing to bring suit against the federal government over the government's purported violation of the very two INA provisions that my amendment addresses. The bill's attempt to overturn the court's decision is futile, as ultimately it is up to the courts to determine whether there is standing. Congress cannot simply declare that standing exists. As I noted earlier, standing is a key mechanism by which the federal courts ensure the proper separation of powers. Ensuring that a dispute involves a concrete injury that is capable of a judicial remedy helps to guarantee that the judiciary stays in its lane and does not veer into areas that the Constitution leaves to the political branches. In addition to evincing disdain for the fundamental constitutional interest in maintaining the separation of powers through adherence to the standing doctrine, H.R. 4848 also attacks our constitutional order by seeking to undermine federalism. As was discussed at length in a hearing before the Constitution Subcommittee a few weeks ago, the Constitution gives the federal government primacy over immigration enforcement matters. By purporting to grant states standing to sue the federal government over immigration enforcement, this legislation is clearly intended to upend the federal supremacy. It's clear that this legislation is essentially a gimmick that in no way could grant standing where a court does not find that Article III standing requirements were met. With respect to the two INA provisions at issue in my amendment, the Supreme Court has clearly held that states lack Article III standing to sue. Therefore, at a minimum, we should strike these parts of the bill that attempt to grant standing for these two provisions. I urge the committee to adopt my amendment, and I yield back.
The gentleman yields back. So
Withdraw my
the
point of
gentleman from
order.
Arizona withdraws his point of order. Is there further discussion on the amendment? Mr. Bishop.
Thank you, Mr. Chairman. In the first, as to sort of the general arguments made by the ranking member and then in support of his amendment repeated, it is true that Congress cannot create standing where none exists. But the issues in standing are whether there is a legally cognizable injury and whether the remedies afforded by the court will furnish redress for those injuries, whether there's redressability. Congress can, by law, affect both things. And that is what Justice Kavanaugh elaborated upon in his concurrence, from which I read in my opening statement. That is to say, Congress can explicitly recognize that injuries suffered by states, acted upon by state attorneys general, resulting from direct violations of law by the Department of Homeland Security are legally cognizable injuries. Congress can confer legal recognition upon that category of injury. And then the other thing that was at issue in the United States versus Texas case is there's a broad statute saying that United States district courts are precluded from issuing injunctions. Actually, all federal courts except for the United States Supreme Court are precluded from issuing injunctions in cases arising under the INA, basically. And so Congress can fix that, and this bill does that by authorizing the appropriate injunctive remedy in the United States District Court. So although the Supreme Court will be the one to determine whether there is standing ultimately, Congress can take a statute to change the situation that existed in United States versus Texas. Now, what is the real basis for objection or real reason for objections from the minority to the statute, or to the bill, excuse me? If you take the section 236 to which this amendment would go, to take these provisions out that are added to the statute in, for example, 236 is about parole authority. And the Biden administration has abused parole and release provisions under INA section 236 to mass release aliens into the United States. And in fact, the federal judge in the case in Florida held that the Department of Homeland Security violated Section 236 by releasing such aliens instead of detaining them as required under Section 235. The judge noted that the Biden administration's, quote, administrative sophistry, which, quote, used an arrest warrant as a de facto release warrant, could not stand under the law. It was a direct undermining and contradiction of the law as passed by Congress. Now, if you want the administration to use parole to be able to have a fig leaf to cover its mass release of migrants into the United States and to characterize those as legal when they are directly illegal, then of course you wouldn't want to change that state of affairs. And it goes to a conversation or a colloquy I had with the ranking member in this committee some weeks ago. The situation for when people talk about the broken immigration system, what's broken is every time there is a new bargain struck on immigration and the statutes are changed, there are provisions added calling for greater border security. Many of the ones we're talking about, and certainly the ones at issue in the United States versus Texas, were added at such a point in 1995 in order to say, well, you've got to do these things. You've got to detain these criminal migrants or criminal aliens and others. And then administrations just don't do it. And what the minority is saying through the comments of the ranking member is, we don't want that situation to change. We want to keep putting provisions about border security in the law, but we don't want the law observed. We want to be able to elect administrations that can do what we want, which is have open borders, and the recurring bargains on border security be damned. This is a very simple device to allow the United States Supreme Court to respond to the invitation of the United States Supreme Court so that that state of affairs does not continue to exist. For that reason, I urge opposition to the amendment, and I yield back.
Gentleman yields back. Is there further discussion? Mr. Ivey.
Thank you, Mr. Chairman. I want to join in the ranking member's concerns here. Ironically, this is essentially sort of a carryover from the Homeland Security arguments that we had, in which, in my view, the majority, violated the Constitution in impeaching Secretary Mayorkas. But these are the same arguments that were made. So I want to walk through some of those. But the attempt to overturn United States v. Texas is based on the fact that United States v. Texas didn't allow them to do what they did a few weeks ago and undercut all of the justifications for the steps that they took. And the real irony is the articles of impeachment actually cite United States v. Texas. So it's interesting to me that after using United States v. Texas to impeach Secretary Mayorkas, now we're getting our Republican colleagues coming up with statutory language to essentially overturn United States v. Texas. But we are where we are. But the reason I have concerns about this is, the ranking members pointed out, there are obvious concerns with respect to standing and separation of powers that Justice Kavanaugh, I thought, made very clear in his ruling. And the standing language is based on Lujan, which was a 1992 Supreme Court case authored by Justice Scalia, one of the supermen of our Republican colleagues over there from the Supreme Court standpoint. But the point there is reemphasized by Justice Kavanaugh as well. And so I think one of the things I'd like to do is just read a couple of the provisions, as I did previously at the hearing before, to address some of these things. First of all, for example, Justice Kavanaugh writes, as this case raises only the narrow Article 3 standing question of whether the federal judiciary may in fact order the executive branch to take enforcement actions against violators of federal law, hereby making more arrests. Under the court's Article 3 precedents and historical practice, the answer is no. Now, I understand there's an effort to try and circumvent that, and Justice Kavanaugh also wrote, I thought pretty eloquently and on point, about the issue with respect to prosecutorial discretion. The bottom line is, as he pointed out, for 27 years, there's been issues like this with respect to the executive branch because they've always lacked sufficient resources to arrest and detain everybody who comes across. Unfortunately, my colleagues on the other side of the aisle blocked an attempt to try and increase funds that could help to address that issue. In fact, I think there was a page one story in the Washington Post today that noted that ICE may have to release thousands of more detainees because they're short on funds to detain them. And United States v. Texas says that the administration has the prosecutorial discretion to do that because they lack the resources to do what you're asking them to do. And then with respect to the the means of, short of drastic constitutional conflict, which I take that to mean impeachment. I'll read Justice Kavanaugh's language again, as I did not only in Homeland Security, but I read it here as well. Congress possesses an array of tools to analyze and influence those policies, those being the federal policies that are being enforced by the administration. Oversight, appropriations, the legislative process, Senate confirmations, to name a few, and through elections. That continues to be the case. Now, the Republicans have already chosen to go the impeachment track, relying primarily on a colloquy between the Solicitor General and an overturned district court case. But Justice Kavanaugh never said that impeachment was a tool that needed to be used. So if one of the rationales behind this statute is to avoid the need for impeachment, as I said then and I say it again, impeachment's not necessary, and it never has been necessary, and it was never said by Justice Kavanaugh. Even though he had that exchange, he expressly did not include impeachment as a tool to be used. So I'm running out of time, but I'll say this, and I join with the ranking member. Let's stop playing these kinds of games with the Constitution. The impeachment was bad enough, but if we're going to challenge Article 3 standing, even though it's clear that that's up to the Constitution to decide what comes in and what doesn't, I don't think this is the right way to go about it. And with that, I yield.
Gentleman's time has expired. Is there further discussion on the amendment? Mr. Roy.
I thank the chair. I guess the tiptoe through the tulips has ended. We have a very strong disagreement here between the two parties in how we view this. The fact of the matter is, what Kavanaugh said or didn't say doesn't mean that impeachment's not a remedy. What my colleagues would do here is continue to allow nothing but the executive branch to make full determinations here on what the impact is on society and the actual concrete injuries, to use that term very purposely, that the people of Texas, the people of Arizona, and others around this country, people of New York, millions across this country, are facing as a result of the dereliction of duty of this administration. That's just the case. So here we are trying to say, well, we just went through this process where for the second time in American history, we impeached a sitting cabinet member for a total failure to carry out his duty, leaving America wide open. And here, my friend from North Carolina is, I think, rightly bringing forward another path, a path in which states can seek redress of their grievances with the very real and concrete injury of the impact to those states for the failure to secure the border as the Constitution contemplates and requires. I mean, the fact of the matter is the Constitution gives Congress power over the court's jurisdiction and makes the states sovereign. That is how the structure of the Constitution was created. So I just literally do not understand the theory being put forward by my colleagues on the other side of the aisle that Congress lacks the power to give states standing to seek redress in court against a federal agency failing to do its job as the laws and the Constitution prescribe. I mean, we do things all this time statutorily. I'm not an enormous fan of declaratory judgments, but they're law, right? I mean, they are a part of the system. And in fact, 28 U.S. Code Section 2201 lays out the case for that. The fact is, what's the problem with allowing sovereign states like Texas or Arizona the ability to take advantage of that when the federal government is derelict in enforcing its federal law? We have gone over this time and time again here in this committee, and I'm happy to walk through the updated numbers because they're much more horrific than the last time we raised this issue here in terms of the impact on Texas, the impact on communities, the deaths and the destruction, the children dying from fentanyl poisoning, the immigrants dying, the state of affairs and its impact to Texas, $12.5 billion. These are very real injuries.
Will the gentleman yield for a question?
Let me finish. I'm happy to engage on that, but I mean, and respect the gentleman, on his thoughts on this kind of thing. But I'm mystified here on the extent to which we are ignoring the reality that's before our eyes. So my colleagues on the other side of the aisle would simply say the executive branch can do whatever it wants. That is the natural result of what my colleagues are saying. They're saying, okay, and again, forget our differences of opinion right here for just a moment on the actual facts before us on border security and immigration. My colleagues on the other side of the aisle want to say, fine, use asylum, use parole, whatever, come everybody around the world, come to the border, get released, we'll figure it out later. Okay, oh, you need to pass a bill that spends lots of money so we can go appoint a bunch of asylum officers to go process all this, which we're in fact creating by using asylum and parole to dump lots of people in the country. Okay, let's just say we just disagree on this. Put all that aside. If the federal government, if the executive branch of the federal government is not doing something, and Congress is saying, wait a minute, you're not doing something you're supposed to do. The Attorney General of the United States just stops enforcing the laws, just stops doing it, and just sits there and lets criminals run amok. And under any administration, Republican or Democrat, what is the redress of the people in Congress, or what is the redress of the people in the states? And what we're saying here is, well, sorry, yeah, you can't impeach a secretary for a complete disregard of his or her duty to carry out the laws. That's what my colleagues on the side of the aisle would say. And we've got a situation where we're saying we can't create a clear path for standing for or expand upon standing jurisprudence here by our act in Congress to say Texas can go into court and say, guys, you've got to actually follow the law. That defies all common sense, and it defies any understanding of why the balance of powers and the separation of powers, Congress's ability and the court's ability to check the executive branch, as was laid out by Justice Alito in his dissent. I yield back.
Gentleman yields back. Who seeks recognition? Mr. Cohen's acting. The gentleman from Tennessee is recognized.
Firstly, I'd just like to say there is a remedy, Mr. Roy. It's very simple. It would involve Texas not being in the SEC and not having an American League team, stay in the NFL and the NBA, and secede from the country. The NFL would be happy to be international. The NBA would be. Now, the SEC is different. It could be an all-American thing. But that's an opportunity.
You're tossing bait out there, and I might jump on it.
I yield to Mr. Nadler, a unionist.
Thank you. Let me begin by saying that most of what Mr. Roy said is irrelevant. It may be true or not true that the administration is doing a good job enforcing the law. Secretary Mayorkas' impeachment is clearly not valid because no one alleged high crimes and misdemeanors. Essentially what was alleged was maladministration, which was rejected by the Constitutional Convention as a grounds for impeachment. We have had a problem that we don't have enough funding to detain people who ought to be detained, and that is a problem. And it's unfortunate that Congress has not appropriated enough money to detain these people, and that the INS apparently, or ICE rather, is going to have to release more people because they don't have the money. It's unfortunate that the Republicans rejected a very tough border bill that was negotiated by Senator Lankford and some others that would have solved most of these problems. All of that having been said, it's irrelevant to this bill. If either a state has suffered an injury cognizable injury, or it hasn't. If it has, it can sue in federal court today. It has standing in federal court today if it meets the requirements for standing, has suffered a cognizable injury. And this bill is unnecessary.
Will the gentleman yield?
If on the other hand, it has not suffered a cognizable injury and therefore has no standing under federal constitutional law, this bill will be ineffective and do nothing, because standing is a constitutional, not a statutory requirement. So either you have standing, in which case the Attorney General can sue today without the bill, or you don't have standing, in which case the Attorney General cannot sue because the bill cannot confer standing. Standing is a constitutional requirement imposed by the Supreme Court as a function of the separation of powers, and either a state has it in a given case or it doesn't, and no bill purporting to grant it has any effect. And now I'll yield. I'll yield to Mr. Cohen. I'm sorry.
Mr. Cohen, would Mr. Cohen yield for colloquy on that point?
I'm going to yield to Mr. Ivey.
I'm not going to take the bait on the SEC either. I did, though, want to go back to Mr. Roy's comments with respect to standing and point out that his dispute isn't with Democrats, it's actually with Justice Kavanaugh and the Supreme Court. The issue you raise is addressed directly, and I go to page 4 of the slip opinion, with respect to standing, and he says basically that standing's based on, as you pointed out, cognizable issues, as the ranking member argued as well. But he noted that in that case, the states have not cited any precedent, history, or tradition of courts ordering the executive branch to change its arrest or prosecution policies so that the executive branch makes more arrests or initiates more prosecutions. On the contrary, this court has previously ruled that a plaintiff lacks standing to bring such a suit. So, oh, and by the way, the statutes that are cited in this amendment are the exact statutes that are cited in United States v. Texas. So there's no, oh, and also in the Articles of Impeachment, by the way. So there's no difference. This isn't one where it doesn't apply here, it did apply there. It's exactly on point. The Supreme Court says you don't have standing to do this. The passage of Congress for a bill that tries to overturn a federal court's decision or a Supreme Court's decision on its position on Article 3 standing, I'm not sure we have the authority to do that. And the other part is you don't even attempt to address the separation of powers piece.
Thank you, Mr.
Which is
Ivey.
the
I'm gonna reclaim
prosecutorial
my
discretion part. So I yield back. Thank you.
Thank you. I just want to recognize the fact that Texas was the state that got us the opinion, or sought an opinion to say the election was unconstitutional in Trump and Biden. And Texas is a state that worked against Roe v. Wade. So maybe it'd be best if sayonara, but I'm out of time and I yield.
Gentleman yields back. The chair now recognizes himself and would yield to the gentleman from North Carolina.
I thank the chairman. It's interesting to me that the ranking member, Mr. Ivey, on the other side, don't want to engage on a point that goes beyond the argument being made. And the ranking member has repeated that standing is a matter of constitutional law, it's to be determined by the court, and I've suggested not only the way Congress can affect that by changing something into a legally cognizable injury, by affecting redressability in the laws that it writes, but I've also read from the opinion of the court. Now, when I first did it, I do want to hasten to say, I misstated. I said that I was reading from Kavanaugh's concurrence. That was a mistake. I was reading from the opinion of the court by Justice Kavanaugh for 6 justices, including Ketanji Brown Jackson, Elena Kagan, and Sonia Sotomayor, who said it might be different if Congress does take specific action. The bill takes specific action. Mr. Ivey suggested that we ought to look to the opinion of the court as the exclusive means to determine what we do in a situation where the executive branch says, thumbs its nose at Congress and says, we're simply not going to follow your law. And he says, well, they didn't say you could impeach, so you're left to something else. You're left to cut funding. Well, how's that going to help the situation? But actually, the fact that the court didn't say we could impeach does leave us with that obvious remedy. Justice Alito's pointed it out in the dissent, and that's what we've just done. The minority raised holy heck over the fact that we did it because it's disruptive and not, but it's the only redress left to Congress. If the executive is not, it says, I'm not going to obey your law, then that's what you have to do. But they don't want to, I'm not sure why you don't want to take that up. Maybe the reason you don't want to take up the fact that Justice Kavanaugh, for the 6-member majority of the United States Supreme Court, laid out how Congress can fix the situation so there doesn't have to be constitutional conflict, is to do exactly what we're doing. They said, here's the roadmap to avoid constitutional conflict and to ensure that the rule of law prevails. That's all that's being done. And one other thing that gets said a lot is, quibbling with what the district court found. Again, the district court found that the categorical decisions by Secretary Mayorkas not to detain and remove were in a situation where they had the resources to do so. Factually, they had unused detention capacity. They were using 40% of detention capacity. No one's challenged that. So the question becomes, Let's just take that as a hypothetical. If there's a situation, take another one, where the executive branch, where the Congress says, you shall do this in the area of immigration, where Congress, the Supreme Court says Congress has plenary authority, complete authority to manage its border, the border of the United States. And the executive branch simply says, we have the resources, you've appropriated sufficient resources to us to do it. We don't like your policy, and therefore we're simply going to not do it. If the rule of law is to survive, that can't stand.
Will the gentleman yield?
If your point is germane to that, yes.
It is. And again, this is Justice Kavanaugh to the last point. The hypothetical about just deciding not to enforce the law, as the court points out, quote, that reality is not an anomaly, it's a constant. That anomaly being them lacking the resources necessary to arrest or remove, quote, all of the non-citizens covered by 1226 and 1231. For the last 27 years since those provisions were enacted in their current form, all 5 presidential administrations have determined that resource constraints necessitated prioritization in making immigration arrests.
It's true, Mr. Ivey, but not all of them decided to use 40% of their detention capacity and to ask Congress for less resources, creating the circumstances in which they could not comply with the law and go farther and farther to not even make a shadow of conforming to law. And that is those are the facts of the case. No one's ever changed the finding of the fact. There's no determination in the United States Supreme Court that those facts didn't exist. They simply said, as long as there's any prosecutorial discretion, as long as you could have a situation in which all the detention capacity gets filled up, and they then have to decide who they're not going to detain, then the situation might differ. That's prosecutorial discretion. Supreme Court said we can't referee that unless the Congress says it wants us to. And that's what this bill does. If you don't want you want the executive branch to rule as a rule of man, then you're not going to support this bill. If you support the rule of law, you will.
Gentleman's time has expired. Thought we had Ms. Ross in the queue, but we will now go to the gentleman from California, Mr. McClintock.
Thank you, Mr. Chairman. First of all, I want to say it was music to my ears to hear the ranking member take such a strict construction view of the impeachment clause. I think we could have saved an awful lot of fuss and bother a few years ago if he'd had this legal epiphany during the Trump impeachments, but I digress. I think this bill would add a degree of stability to what's become a terribly unstable relationship between the executive branch and the legislative branch with respect to what constitutes faithful execution of the law. I think the courts are in a much better position to navigate this issue, which is essentially a legal question, than is the Congress with its highly politicized and partisan nature. I think the best way to address this question is to allow states that are injured by unenforcement or under-enforcement of the law to be able to approach the judiciary to get a judgment that clearly delineates the enforcement responsibilities of the executive. That judgment would provide all parties with a very clear, bright line as to the executive's legal responsibilities to enforce the law. And as long as they operate within these boundaries, they are unimpeachable, period. The doctrine of nullification is a poisonous doctrine propounded by the likes of John C. Calhoun that states have the right to ignore federal law they don't care for. That's obviously destructive to the fundamental principles of a constitutional republic that's based on the rule of law. But what we're seeing today with respect to immigration law is an assertion of presidential nullification, that the executive can simply ignore or minimize laws that he doesn't like. And that, too, is destructive of the rule of law. We've just seen a legislative response to that position with the impeachment of a cabinet secretary. Now, as you all know, I believe that fails to reach the threshold for impeachment under our Constitution, but I also believe that we would see much less temptation for any Congress to abuse the impeachment clause if such judicial guidance were available to both the legislative and the executive branches. The executive branch would be placed on notice as to the legal obligations that it has, and the legislative branch would have the judicial guidance on whether the executive is acting within its constitutional authority. I hope my colleagues will consider that and support this bill, and I'll be happy to yield to Mr. Bishop if there's anything to add. And I yield back.
I'll take.
Gentleman from
Mr.
Texas.
Roy.
Yeah, I would just note one point on the issue of the maladministration point, with all due respect to my friend from California, whose time I'm now taking, and the ranking member, that in fact there were recognition at the time under Blackstone that maladministration was subsumed into high crimes and misdemeanors.
Well, I'll reclaim my time for just a moment to address that point. Blackstone is referring to English version of impeachment, which is radically different from the American version. Under the English version of the Parliament could impeach anybody they wanted, impose any sentence they wanted, including death. The American founders made it very clear that they had a very different model in mind. In fact, Hamilton made that clear in Federalist 65 and in Federalist 69, where he pointed out that once a president is impeached and removed from office, which was the limitation of the impeachment power, the judiciary could then prosecute him for the actual underlying crime.
Well, the gentleman from California, I read those exact passages as well, and note the difference with English law. But at the point at the time, there was no vote, there was no determination on that issue. But the point of my raising the issue now is that with respect to where we sit in this moment, we are left with making decisions as Congress on how to react to an executive branch not carrying out its law. So the fact is, as the gentleman from California raises, that in the gentleman from California's view, that it is pushing the envelope or extending into an area of defining high crime misdemeanor that the gentleman did not agree with, that the vast majority, obviously, of the Republicans and a majority of this body did.
Well,
because as a result,
reclaiming my time for just a moment, they did, in this case, they took the opposite position to oppose the impeachments of President Trump. I would argue that both sides ought to be consistent, whether the shoe is on the Democratic foot or the Republican foot.
Right, and I would only point out, your point is, in here, we've got a redress that Congress is using, which the gentleman from California disagrees with using, because we are not answering the question which this effort by my friend from North Carolina is attempting to address,
I think
bring it back to the courts.
I think that the bill before us would add clarity to avoid that kind of discussion in the future. I yield back.
The gentleman yields back. We have the gentlelady from Georgia is recognized.
Thank you, Chairman. I'm truly in agreement with the argument that's being stated by my colleague, esteemed colleague from the state of Maryland, Mr. Ivey, and so I will yield the balance of my time to him.
I thank the gentlelady. Just quickly on the maladministration language, I thought, and by the way, I wish we had actually addressed these impeachment issues in judiciary. It was kind of ironic that it would just go through Homeland Security, but we'll leave that for another day. Maladministration was expressly rejected by Madison during the constitutional debate. That was recorded in the notes. And that's part of the reason that it should not be a standard used for impeachment now. But setting that to the side, back to this issue, I did want to continue to remind my colleagues about what Justice Kavanaugh wrote with respect to the issues of the separation of powers and with respect to the enforcement of these particular statutes. And I'll read this explicitly from his writing. In light of inevitable resource constraints and regularly changing public safety and public welfare needs, which are the ones I talked about previously, the executive branch must balance many factors when devising arrest and prosecution policies. That complicated balancing process, in turn, leaves courts without meaningful standards for assessing these policies. I'll skip the citations. Therefore, in both Article III cases and Administrative Procedure Act cases, this court has consistently recognized that federal courts are generally not the proper forum for resolving claims that the executive branch should make more arrests or bring more prosecutions. And then the court continues on to say, all of these considerations help explain why federal courts have not traditionally entertained lawsuits of this kind. by concluding that Texas and Louisiana lack standing here, we abide by and reinforce the proper role of the federal judiciary under Article 3. And it goes on to address the state's novel arguments and that sort of thing.
Would the gentleman yield?
I will.
What do you make of the roadmap that Justice Kavanaugh offers in the majority opinion to how Congress can take action to ensure that the rule of law governs the executive?
Well, I think well, are you referring to the four-part test or the part that I read earlier?
The part that I read where he specifically said what Congress could do, confer legally recognizable, cognizable injury, and also empower the federal courts to provide remedies that would give redress.
I'll say two quick things. One is, I don't think your amendment addresses the four-part test that Justice Kavanaugh lays out in this opinion. And secondly, and more importantly, based on what I just read, it totally ignores the separation of powers issue based on the prosecutorial discretion standard, where the courts clearly and always give the executive the authority to exercise prosecutorial discretion. That's clear here.
Do you mean
that's
that
clear in federal courts as well with the Department of Justice and the like? I mean, it's just sort of standard fare, and that's what I just read. That's the point that Justice Kavanaugh just made.
Right, but both parts are in the opinion. Do you believe he didn't mean what he said when he told Congress how it could act to confer standing?
I believe what he said with respect to his recognition of the clear absence of resources to carry out the function that you all seem to think can happen by waving a magic wand, as opposed to providing the actual resources to do it, namely arrest and detain everybody, which is impossible, and that's what he just recognized. I just read that a few minutes ago. And then with respect to this, as Justice Kavanaugh points out, that's one of the main reasons that the type of determination you're trying to force the court into, via state attorney generals, by the way, and not even through at the federal level, but that's why Article 3, suggests that they should not be handling these kinds of cases. Somebody else over there mentioned, this is a legal question, not a political question, but I do want to note that the Supreme Court made a legal determination that this is a political question. That's the separation of powers piece, and that's why they don't want to take, get the courts in the middle of it. So, you're going to vote the way you're going to vote. I can see that's where we're going with this, but it's clearly in contrast to the argument that you're making, that you made with respect to the articles of impeachment, and it's in direct contrast to the United States v. Texas, which is why you're trying to essentially overturn it. And with that, I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Arizona.
Thank you, Mr. Chairman. I just want to start by talking about the funding issue, which has been raised multiple times by the Democrats. I find that an intriguing argument because we never heard that there was not enough money when they first started the catch and release programs again in late January of 2021. They had plenty of money. They could have detained, but chose not to. So let's get to this. I just want to raise a couple of issues. First of all, Kavanaugh didn't really address, he tried to distinguish, I think, the Massachusetts versus EPA case, but he didn't really do a convincing job, at least not for me, certainly not for Gorsuch and not for Alito, but they didn't overturn that law. And that law says that states get special solicitude regarding standing. Special solicitude for standing is basically the recognition by the Supreme Court that there are cases where states should get standing when an ordinary person would not otherwise get standing. And so the reason I bring that up is that what's happening with this statute is consistent with what Kavanaugh said, but it also is consistent with Massachusetts, because we're trying to address here what is an injury, what is an injury, and what is the remedy, and should a state be allowed to raise that? And we're asserting that that's the case here. And that's consistent with Massachusetts, which is still good law. That's still good law. So, well, okay, yeah, it's still law. I'm not sure. When I say good law, that's a term of art, of course. It is good law. It is active law. And what that means then is that by us going in and saying this is the will of Congress, the courts are going to be more inclined, in my opinion, to say, well, you know, under the doctrine of Massachusetts, then the states should have standing here. And the Congress has indicated its will. The state's trying to fill in and request relief if they've iterated the damage. Now, I want to go further with that and talk about the confusion that the U.S. Supreme Court has given with regard to border security. I harken back to the U.S. versus Arizona case, where the federal government was trying to remove any capacity of the state of Arizona to defend itself from the onslaught that was coming on it at the time. And this is about 15 years ago. It was so bad that our then Governor Janet Napolitano wrote to the administration and said, we want $100 million because it's cost us that much just in incarceration costs. So with that in mind, the Supreme Court said that the field belongs solely to the federal government. If the federal government vacates the field, then the state can then enter the field. I continue to make the argument that the field has been vacated by the federal government. The states then can intercede. I think that this Texas case, Texas-Louisiana trying to fill the field itself and being denied their relief on standing grounds, I think we have to go back and look at the Massachusetts versus EPA, the special solicitude, and the fact that Kavanaugh himself gave us an avenue where Congress can weigh in and try to ameliorate standing concerns. I support the underlying bill, I support the ANS, and I oppose the Nadler amendment that we're considering right now. And if the gentleman from North Carolina, okay. With that,
I think maybe everything's been said, although maybe not everybody's yet said it, but it's just very straightforward. And I think telling that the objections were to, impeachment was a gross violation, so you can't vindicate the law that way, that is thought by the minority. And so if you go back to the case and you go back to the opinion that was supported by the liberal and conservative wings of the court with 6 justices, and they say, here's how Congress could fix this when in situations where it believes it appropriate to do so. Look, the bottom line remains clear. They just don't want to fix open borders. That's all there is to it.
yeah, yield back.
Gentleman yields back. The chair recognizes, the gentlelady from Washington is recognized.
Thank you. I yield my time to Mr. Ivey.
Mr. Ivey, 15 minutes.
I can't let this bone go here. Yeah, and it's the SEC comment that really got, no, I apologize. All right. Look, with respect to, Congressman Biggs' comments, a couple of quick things. One is that the Supreme Court in this case, Texas, pointed out that immigration has a special status, as we all know, because it involves the executive branch dealing with, foreign policy issues, essentially. And, that's not addressed in the Massachusetts case you're relying on. And then also, I kind of wanted to mention, too, just Congressman Bishop's comment about our position. It's really not so much that we want open borders. I've been reading to you Justice Kavanaugh's opinion, which, you're saying you're relying on, and the articles of impeachment clearly referenced, although ironically, the articles of impeachment relied on Alito's dissent, and he was the lone dissenter. It was an 8-1 case. So you find yourself, standing against the other 8, essentially. The language you keep referencing with respect to supporting this amendment is clearly dicta. And it clearly also ignores the separation of powers issue that you haven't really discussed, which is, the resource piece that Justice Kavanaugh pointed out, and I guess I could read it to you again, although I don't know that it's going to further the debate at this point. You've heard it already. He's already, he said for 27 years, and through 5 presidents, they haven't had the resources to arrest and detain everybody. And that's undeniably true. There's no set of facts that were asserted in the case or by the Republicans here or during impeachment that suggest otherwise. You can't arrest and detain all of them. So therefore, the executive branch has prosecutorial discretion. It's their discretion to make decisions about where to draw those lines. And then Justice Kavanaugh explicitly connected the executive branch having that discretion with deference from the courts, including the Supreme Court, under Article 3 of the Constitution. I mean, it's, I think pretty straightforward that what you're trying to do here flies directly into the teeth of that. And it's a frontal assault on United States v. Texas, which you got the right to do, I guess, but to then say that this opinion supports what you're doing in essentially trying to overthrow what Kavanaugh wrote, I think is hard to support. I'll say it that way. And with that, I'll yield back to Ms. Jayapal.
Would the gentlelady yield for a question?
To Mr. Ivey, sure.
Yes, please.
Yeah, I yield to you.
I just have one question, because I'm trying to understand the effect if this were to become law. And earlier you mentioned foreign policy, and that's why I'm asking. The state of Texas is only dealing with its territorial boundary, and if individuals were to come to a port of entry and present themselves, Texas would have no say. Is that correct under your interpretation if this bill became law?
I don't know that it goes there. I think what Justice Kavanaugh was talking about, though, is because you're dealing with something involving, in this instance, say Mexico and Texas, a foreign country, and in the immigration context, the courts are going to give additional discretion to the executive, or deference to the executive branch as they exercise their discretion.
Well, the question, though, is, isn't Texas on Texas land of the state of Texas basically asserting their anti-trespass? So, I know that there's a lot of debate about cutting fence, not cutting fence, but from a practical standpoint, if everybody who wanted to come into this country, not with drugs and human trafficking, but to present themselves for a parole, came to the port of entry gate, wouldn't that circumvent Texas while people who are coming on and trespassing onto Texas private or Texas public property are actually where the governor is in place? I just want to understand what we're empowering, and it seems like we're empowering in-state and under no circumstances, because I'm not disagreeing, you go to the middle of the Rio Grande, you may be in Mexico, and that's outside of Texas's jurisdiction, but the fence, as I understand it now, is in Texas.
May I answer? I'm not sure about the fence part, but if you're talking about each state having the ability to enforce anti-trespass laws, I think the reason the Supreme Court and the federal government don't go in that direction with respect to migration, immigration, is because you would have potentially 50 different versions of what would be crossing that line or not.
Time of the gentlelady has expired. Gentlelady yields back. The gentleman from New Jersey, Mr. Van Jur, is recognized.
Thank you, Mr. Chairman. This is a fascinating, interesting, enjoyable discussion. It is. However, I just wanted, there were certain things, and I might digress a tiny bit, but the ranking member from New York mentioned that the Republicans rejected a good border bill, a tough border bill. I can't just let that statement go. The border bill that the Senate did, and will never see the light of day, hope to God, in the House, did nothing to stop catch and release. It did nothing to continue to build the wall. It did not institute the Remain in Mexico policy. It didn't allow the immediate expediting of individuals who did get through back to their country of origin. It did allow close to 2 million illegals a year into the United States, almost codifying what is illegal. it did allow 50,000 work permits per year. And you know what I want to say here is, I don't know that we'd have to have these discussions, colloquies, and debates if the executive branch just did its damn job. They're not doing their job. The executive branch itself is basically allowing the law to be broken, and I would maintain is breaking the law. This administration is terrible. It doesn't enforce the law of the land. And as far as resources that would mention, believe me, if this administration was enforcing the law and instituting all of the things that I just mentioned that need to be done and more, if they did all that, I can personally guarantee that this Congress, at least this side of the aisle, would now, because of the extreme nature of the situation, get those resources to the administration so they could do their job. But meanwhile, they're not. And meanwhile, it's incumbent upon the Judiciary Committee and the House of Representatives to ensure that we do everything within our legal ability and framework to stop the disaster that's going on. Because any of the folks at home that might be listening to this conversation, they may not understand all the technicalities. They may not understand the interesting parts of the debate and the fascinating intellectual duel that takes place. But you know what they do understand? They do understand that 2 cops were beaten up by over a dozen individuals who came here illegally because we couldn't even check who they were and where they're going. They do understand what it's doing to our country. So I support this legislation. I support all the legislation that's coming to me today.
With the
And
gentleman.
I thank Representative Bishop, my friend from North Carolina, and yes, I will yield.
I thank the gentleman. It affords an opportunity to make a little, or advance your point in this way. I said a moment ago that Democrats want open borders. That's the reason they're opposed to this, but it's actually a little more complex. They want open borders, but they have a desperate political need to avoid the political consequences of open borders. What is happening is throughout the country, people in every area, every region, every city are experiencing the catastrophic consequences of uncontrolled open borders. And so what the bill, frankly, that came from the Senate was about was an exercise in excuse-making, shifting political blame, because all of the blame belongs on the Biden administration that undertook this radical policy in the teeth of congressionally enacted law. So much of what they've done, not every single thing, but much of it has been absolutely lawless. In addition to stupid, lawless. And so the reason this bill needs to get in the hopper is because leadership in the Republican leadership in the House, the Speaker has said, we are going to have actual border security, and we're not going to proceed until we do. You can pass all the bills like that came out of the Senate that you want, and the other side will say, well, see, we've gotten everything covered because it's Congress's fault, and Congress is a broken immigration system, and so Congress has done a bill, and they can keep rolling. They can institutionalize the policy that they embarked upon January 2021, which has led to the circumstances that exist today that are destroying the president politically and the Democrats.
And I'd like to reclaim my time.
Yes, sir.
And I thank you for that, and you're exactly right. So getting back to what the ranking member said, that bill that came from the Senate is a nothing burger. It did nothing, it didn't accomplish anything, and it did more harm than good. And as my friend from North Carolina said, institutionalized and legalized what is an illegal activity. I thank you. I yield back.
Gentleman yields back. The gentlelady from Texas is recognized.
Thank you, Mr. Chairman. I think this is a good point in time for a little bit of fact-checking. I'd like to speak directly to the American people at this point. I represent a border community, an incredible border community, El Paso, Texas, the only member on this committee who goes back home to the border every in-district work period, the only one who speaks regularly with NGOs, local governments, Border Patrol, OFO, who really can speak with some authority on this. I can tell you the biggest challenge that we face today is congressional inaction, but even more than congressional inaction is the intransigence of my Republican colleagues. The president asked us for added funding, a border supplemental. It now sits on a shelf gathering dust. So Border Patrol agents, OFO officers in my community do not have access to the resources that they need in order to provide border security. Whose fault is that? My Republican colleagues. The Senate worked on a bipartisan compromise, and before the ink was dry, who opposed it? Republican colleagues. Something that Republicans on the Senate side claimed would be the toughest border legislation ever passed by Congress. And what did House Republicans do? They balked at it before they even read the text. They've made it clear over and over and over again, they don't want a solution, they want the issue, they want to create chaos, and they do that by withholding funding for the Department of Homeland Security. I think it is also very important to point out the fact that they keep saying that the president alone can fix this. Actually, I didn't hear them saying that when they passed their ridiculous H.R. 2. They claimed that that legislation was needed, but then all of a sudden, no, the president alone can fix it. As an example of the incredible hypocrisy coming from the other side of the aisle, they keep claiming that the president is not doing everything he can under the law. I'll give you an example. According to them, they'd like to see every asylum seeker jailed. Every single person arriving at our nation's southern border, they want jailed. I think that's not just a terrible waste of money, but I think it's inhumane and it's not necessary when there are alternatives to detention, but that's what they want. And guess what? They have failed to give the president the funding to do it. So I don't know where they think the president will come up with the money to do what they claim he's not doing. It sure is not coming from Congress. I don't know if he's supposed to look under couches in the White House for spare change, but it's been this House Republican group that has withheld the resources and withheld legislation, absolutely failing to do their job. So every time you hear a member of the GOP blame the president, it really, I hope the American people hold up a mirror to them and remind them of what they have failed to do, and what they have failed to do is their job. Thank you, Mr. Chairman. I yield back.
Gentlelady yields back, seeks recognition. The gentleman from California.
Thank you, Mr. Chairman. The gentlelady from Texas, I don't know, maybe you have the same memory as President Biden, but I came over to you and reminded you that I have 55 miles of the Mexican border east of San Diego, and that I have led more than 20 trips to the border with attorneys generals, members of Congress, even former baseball player Steve Garvey, and both Republicans and Democrats, but mayors and so on. We spend a lot of time at the border, and yes, we do talk to those NGOs. So hopefully, in the future, we can at least agree that there's more than one of us on this committee that has the Mexican border. Notwithstanding that, thank you, but notwithstanding that, the Mexican border, or the border of every foreign country, now has no border. And that's what we're dealing with here today, is the right of all 50 states to take action when possible. Now, the gentlelady, rightfully so, said the president's run out of money. He's run out of money by giving tickets, air tickets, to people to go where they want to go when they enter the country. He's run out of money by misusing border assets, including literally costing more to not build a fence/wall from day one. So I have some sympathy for he's out of money, but I have no belief that if we gave him more money, that anything would change. As a matter of fact, I'm quite sure what he wants is more money for more housing for New York so they can be happy with him instead of unhappy. Now, having said that, there's no question at all that, and I've been here over 20 years, that sometime in the future, when the Democrats are in the majority, they will propose a very similar bill on a different subject. They will want to give every attorney general, as they have for the 20 years I've served before, the right to sue, and every individual. So the debate here, we bring it back to what it is. The debate is about the injured states, and albeit many of the Democrat mayors are saying that they're injured too, having standing to, in fact, do something about it to the extent they can. Now, we realize that if you show up at the border and the president issues a blanket parole, which is in violation with the parole statute, he just automatically paroles everybody, there's not much they can do. And Mr. Ivey said rightfully so, you know, some parts of this are vested only in the president and vested in the foreign powers that work with him. Having said that, we're here today because the president has not faithfully enforced the laws in a way that was previously demonstrated by the previous administration. It's that simple. The numbers reflect it. And I'm going to use the remaining 2 minutes, not that I'm a conspiracy person, but I believe that you can and should predict why something happens. I believe that this president, in concert with his executives and his advisors, from day one wanted to change America and change the demographics of America for political purposes. I believe that he made the decision to get 10 or 12 million people into the next census that would predominantly live in minority areas, that my Democrat friends, at least in the blue states, would be able to draw districts to enhance not only the number of members of the House, but in fact, change the outcome of the Electoral College. Now, if my members on the other side don't believe in that, then we should begin looking at the census so that we not count people that have been paroled in this country as though they were voting citizens for redistricting. We have until 2030. But I will tell you, as I propose that, I know that I will not find a Democrat co-sponsor, because for a Democrat to do it is to work against the interest of the president and this administration, who knowingly are letting people into this country, not because they're going to vote, but because the way the census works and then the apportionment, the White House and the House of Representatives are at stake in 2032. If we don't change the law, if we don't do what former President Trump and Wilbur Ross were attempting to do, which is get back to asking the question, are you a citizen or not? And if you're not a citizen, you don't get counted for the reapportionment. That is what is at stake here. So I'm going to vote for this bill. I'm going to vote for every bill, but the most important bill is one that we're going to have to do to keep from losing our democracy because of the treasonous work of this president. I yield back.
Gentleman yields back. The gentlelady from Pennsylvania is recognized.
I move to strike the last word.
Gentlelady is recognized.
I cannot begin to say how offensive I found that last speech and that embrace of replacement theory is, but I would like to yield my time to Ms. Escobar.
Thank you so much, Ms. Scanlon. The open and brazen use of the great replacement theory by Republicans really should send a chill down the spine of every American. And it is not just vile and offensive, but it's dangerous. And I'd like to remind my colleagues that that rhetoric that embraces the great replacement theory was what was used on August 3rd, 2019, by a white supremacist who came into my community to slaughter immigrants and Hispanics because he was concerned about this great replacement. So I would just, again, like to ask my Republican colleagues to please be cognizant of the consequences to their language. But I think it's really important also to remember what is going on here. Republicans don't want to address the challenges and the opportunities that we face with immigration. It's a challenge because we're seeing a Western hemispheric refugee crisis that's impacting our country and other countries in the Western Hemisphere. And instead of seeing it also as an opportunity to modernize our outdated immigration laws, because frankly, we need immigrants in our country. Immigrants make us stronger, more innovative. Immigrants make our country better. Instead of looking at this great challenge as an opportunity to change Byzantine laws, what do? They try to not do their job and they try to rile up their base. The same thing is happening in my state, unfortunately, of Texas, where we have a governor who has spent tens of billions of dollars trying to rile up his base with border tactics that haven't changed anything and have only caused civil rights violations and a terrible waste of taxpayer money. But I will close before I yield back to Ms. Scanlon by saying, for my colleague from California who's no longer here, he obviously has a problem listening, because what I said was I'm the only member who lives on the border and goes home to the border every time we have an in-district work period. And for his information, I have brought nearly 25% of Congress to the border for holistic trips to view how the system isn't working and how we in Congress should be fixing it. With that, I'll yield back my time to Ms. Scanlon.
Thank you. And I just have to take such offense. More than 1 in 10 people in my district were born in another country. The vast majority of them are productive members of our community. They come from Ukraine, they come from Ireland, they come from Africa, they come from South America. They are hardworking people raising their families, paying their taxes, and what I just heard was so offensive that I really just had to respond. Thank you.
Would the gentlelady yield?
Yes, I yield to Ms. Jayapal.
Thank you. I just want to echo how offensive the gentleman's comment was, and just remind him that it was actually Ronald Reagan who signed the last bill that granted undocumented immigrants status in 1986, legalized 2.3 million undocumented immigrants. The next year passed an executive order that prevented their kids from being deported. So you're really talking about conspiracy theories here? What is going on in this committee, and how disgusting and inappropriate that comment was. And I really hope that we can get back to some bills that we agree on, like FISA, and getting our FISA bill to the floor, because this markup is ridiculous. And that comment was absurd, offensive, and dangerous. I yield back.
Gentlelady yields back to Ms. Scanlon. Ms. Scanlon.
I yield back.
Ms. Scanlon yields back. I would say I'm all in favor of getting FISA to the floor with our amendments as quickly as we can, but the chair now recognizes the gentleman from Alabama.
Thank you, Mr. Chairman, and I'll yield to Mr. Vandry.
Thank you, Mr. Chairman. I just can't let this go.
It's your amendment, isn't it?
We all believe in immigration. We all believe we need a better legal immigration. We don't believe that we should give more money to process illegal immigration. Let me tell you an immigration story that just, we all have immigrants in our district. I certainly have a good number. Gentleman grew to be a friend. He is a friend of mine, visited his little store and gas station every week, twice a week, got gas, spoke to him, bought stuff. And he talked about how he was in this country and how more than anything, he had to wait to get in, and now that he was in, that he was waiting to be, in a legal way, a legal citizen in the United States of America. He went through the process. And I'll never forget the day that he was sworn in, because I saw him right afterward. He came back to his store because he worked like 15 hours a day. His kids were models in the school. His wife was a wonderful person. He was a wonderful person, a great part of the community. And he talked to me, and he teared up because he spoke about how proud he was to be a United States citizen, how proud he was of America, how much he believed in the United States of America, and that it was worth the long and arduous wait. He wasn't with the immigrants, again, who beat up those cops in New York, and then when they were immediately released by ultra-liberal prosecutors, walked by the media and the video cameras and gave 2 middle fingers. Those 2 middle fingers were to America. We don't know who's coming in, how they're coming in, what they're going to do, whether they're on the terror watch list, what they believe in, how they're related to the drug cartels, which control the border. No congressperson controls the border. The border control doesn't control the damn border right now. It's the drug cartels. Nobody's saying anything about illegal immigrants. Nobody is saying anything about immigrants. Almost all of us who sit on this committee at some point in time either are immigrants, or their parents were, or their grandparents were, or their great-grandparents were. Legal immigration, there's nothing wrong with it. But what we are doing to this country now is wrong. You know, when our forefathers came here, when those that worked so hard to become part of America, and many of these people, when they came here, they believed in America. They wanted to become part of the United States of America. They love this country. To give more money to a process that allows illegal immigrants to just come into the country in huge numbers that we cannot absorb is wrong. It's wrong to those legal immigrants that are here. And the people who feel most strongly about this issue aren't fifth-generation Americans. The ones that I speak to are recent legal immigrants who came to the United States of America and believe in this country, like my friend Kayla. So let's stop it. Let's not do the blame game. What's going on now is wrong, and it's bad, and more money's not going to be the answer. And that bill from the Senate was a damn bad bill that did nothing. So as many times as you want to pretend politically that it did something, I'm going to tell you it made it worse. So it's tell the truth time. I yield back.
Mr. Chairman, I'd like to yield the remainder of my time to Mr. Bishop.
I thank the gentleman. I regret there's no bipartisan agreement on this bill, but I'm not surprised by it, because in that bill that came from the Senate, same one that was designed to furnish more money to bring more people into the country illegally faster and intensify all the conditions that we've seen around the country, had this provision that is the polar opposite of what we're proposing here. Notwithstanding any other provision of this act, judicial review of any decision or action in this section shall be governed only by the United States District Court for the District of Columbia, which shall have sole and original jurisdiction to hear challenges, whether constitutional or otherwise, to the validity of this law or any written policy directive, written policy guideline, written procedure, or the implementation thereof issued by or under the authority of the Secretary who implement this section. In other words, Democrats not only don't want the AGs to be able to have an opportunity to challenge wrong violations of law, they want to seal it up in the swamp so nobody can make sure the law is enforced. And I yield.
Yield back, Mr. Chairman.
Gentleman yields back. The question occurs on...
No, we got one more. I can't let the swamp go. Come on. Go.
Mr. Chair.
Gentleman,
I'm not surprised.
Recognized.
I am going to trust Mr. Ivey to rebut better than I can, but I just want to express my utter, complete disappointment and outrage with the level of conversation in this committee. Mr. Ivey?
I thank my colleague.
Gentleman, yield.
Just a couple of things. I don't want the record to be, I think the replacement theory piece has been addressed. I'm troubled by those comments too, and I have a fairly large population in my district, largely immigrants from Central and South America. Unlike many of you all, many of mine have been in my district for over 10 years, up to 20 years now. I find them to be very hardworking people. They send their kids to school. They do jobs. They pay taxes. They've been outstanding members of the community, in my view. So. Whether you think it's to replace them or for the census or whatever, I don't see any of that. I don't believe any of that, and I'm glad we have them. Let me say this. The comments about we don't need more resources is ridiculous. I mean, those of you on the Homeland Security Committee with me sat there through hearing after hearing after hearing where Border Patrol agents would come in and we say, what do you need? They say, we need more resources. We don't have enough people to patrol. We've got people who get burned out. They leave because we're not paying them as much as other law enforcement positions. I mean, and that's just on the personnel level. Obviously, they need more resources. They need more people to cover the border. And that's not even discussing the northern border, which is one of the issues that came up at a hearing, too. And then when I went down to the Rio Grande border area, The border agents that we spoke to there on the ground were saying the same things. You know, so I think that's clearly wrong. And, you know, the arguments about, you know, I guess you think we have enough bed space and, you know, space to detain people, although it's clear, as Justice Kavanaugh noted again, that that's not the case and hasn't been the case for 27 years and through 5 presidents. But I also want to bring to your attention today's article by Nick Miroff in the Washington Post. After border bill failure, ICE considers mass release to close budget gap. And this article talks about, and the budget, and the bill they're talking about is the Senate bill that you all are talking about like it's, I don't know, something horrific, but it, you know, it seemed to me it was a bipartisan effort to try and address these concerns. But it contained things in it that I thought you would have liked. For example, $2.6 billion for deportation flights and $3.2 billion for detention capacity. Now, obviously, we know that they don't have as much capacity to detain and arrest as you'd like. Seems to me that adding more funds to do that makes sense. Also, adjudicating the cases faster, since some of these cases take 5, 6, 7 years before they get before a judge. Wouldn't it make sense to have more judges in place to adjudicate the cases faster? Obviously. Well, they don't do it for free. You have to pay the judges to put them in place and the court, you know, equipment and personnel around them to do it effectively. And then on the Senate bill piece, you know, I get what happened there. I heard the same thing you all heard. You know, former President Trump said, we need to kill this bill, and he wasn't trying to hide why to do it. He was very explicit that he didn't want to give any kind of win or, you know, benefit to President Biden or those running for re-election on the Democratic side. But I would note that the outcome in New York on Tuesday, just a few days ago, suggests that my Republican colleagues aren't going to be able to play this game. The public sees that this is a major problem, obviously, but they also know that we need resources to address it and fix the problem. They know that. They know you need more Border Patrol agents. They know we need more judges and the like. So let's stop playing that game and actually start addressing those issues. You impeached Mayorkas in the Homeland Security Committee. You sent our HR 2, which was DOA, obviously, because it contained so many silly poison pills that nobody would support it. McConnell said right off the bat, we can't move that forward. But they did put together a bipartisan bill for discussion at a minimum, and we won't even take it up. Johnson, the Speaker Johnson was saying it wouldn't even be considered before he got over here. So I'll stop there, but can we at least try and address the issues that are important to the American people on this front? Can we try and do the things that we know that they need to get done so we can deal with this problem? And with that, I yield back, and I thank the gentlelady for the time.
Gentlelady yields back. Not to be outdone by the Ivy filibuster, Ms. Jackson Lee seeks recognition.
I think I've got the lead today.
You sure do, but that's fine. The gentlelady from Texas is recognized.
Yeah, I yield to the distinguished gentleman for that honor from Maryland, but I am, his words are worthy of being heard. Mr. Chairman, thank you for your graciousness. We think that our ranking member has really highlighted the concern that we all offer. In the next couple of weeks, we will not be in Washington really addressing the question of comprehensive immigration reform, which we could do, which would also include the help that Mr. Bishop wants by adding to it the border protection funding. Just think if we put in legislation, and I just want to say to my colleagues, I intend to reintroduce a bill that I had introduced over the years of Save America Comprehensive Immigration Reform Bill to add to a comprehensive approach to some other very important bills that have been introduced as well. And the idea is to do the section-by-section needs that are the most relevant point to immigration reform. Access to citizenship. My bill was written before the DACA concept. The cleaning up of the long waits of legal immigration when there were individuals who were in the legal system who were waiting, at that time, the Irish, the Polish, the people from the Philippines. So you know there is history in this legislation where people have tried to access citizenship and cannot do so. And then to make sure that we have a framework so that individuals who came or had intent to do harm to the United States, because that's what I hear from my constituents. They realize the economic engine that immigration is. Sitting in the Budget Committee yesterday, it's more than $1 trillion. Immigration, done the right way, is more than $1 trillion to the economy in job creation, and as well the presence of immigrants creating the consumer base that is unbelievable. So I can't imagine, I'm tying this all the way to Mr. Bishop's wanting to give additional authority to states' attorney generals out of the basic Constitution that makes it clear subsequently, it didn't start out in the writing of the Constitution, but subsequently, that immigration will be left to the federal government. And so I would be markedly concerned on this partisan bill that would give to attorneys general the time to go grocery shopping and to pick fruits and vegetables, and now I'm going to the meat counter, and whenever I feel like it, I'm going to file a lawsuit. I'm going to use the powers, and I'm not going to improve anything regarding immigration reform. I'm just going to sit here and do this time after time. I think the underlying bill is unconstitutional. It goes directly against the Supreme Court's settled precedent in Spokeo Inc. versus Robbins, which explicitly states that a statutory right to sue does not constitute an injury for purposes of standing. So that is separate and apart from immigration law. But if we're speaking specifically about immigration, then we are giving to the states authority that has been left to the federal government. We have not rejected or rebuffed our responsibilities for immigration. And I just can't imagine how the amendment, the bill that Mr. Bishop has is going to answer that question. Now, I want to specifically say that the amendment of Mr. Nadler strikes 22B and 2E of the bill. Those are the two provisions of the Immigration Nationality Act that Texas sued over, and the Supreme Court found Texas does not have the standing. They're trying to overturn these sections. My point is to go beyond the standing and just to say that the whole underpinning of the bill of Mr. Bishop is not going to solve our problems of immigration reform. So I just want to conclude by offering to my colleagues action items funding the supplemental Southern Border Bill would help us. Dealing with the immigration reform legislation would help us, and not passing the underlying bill of H.R. 7322 would help us, because I cannot imagine, I just cannot imagine the hysteria that would be created by various states' attorney generals, which I respect, they have their authority, filing lawsuits all over America, talking about immigration injuries. How insulting. So, Mr. Chairman, I would ask that the gentleman, Mr. Nadler's amendment be accepted and the underlying amendment, underlying legislation be opposed. I yield back.
Gentlelady yields back. The question occurs on the amendment from the gentleman from New York. All those in favor say aye.
Aye.
Those opposed, no.
No.
In the opinion of the chairs, the noes have it.
Chairman, I ask for the ayes and nays.
The ranking member asks for a roll call. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Buck? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Spartz? Mr. Fitzgerald? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Bentz? Mr. Klein? Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Aye. Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson? Mr. Schiff? Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Dean? Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Ms. Bush votes aye. Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant? Aye. Ms. Ballant votes aye. Mr. Gates votes no. Mr. Biggs votes no. Mr. Klein? Mr. Klein votes no. Mr. Massey, you're not recorded. Mr. Massey votes no.
Tiffany?
Mr. Tiffany, you're not recorded.
No.
Mr. Tiffany votes no.
Ms. Dean?
Ms. Dean, you're not recorded. Ms. Dean votes aye.
Clerk will report.
Mr. Chairman, there are 12 ayes and 17 noes.
The amendment is not agreed upon. The chair now recognizes gentlelady from Washington to offer an amendment.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. Point of order reserved by the gentleman from Arizona.
Amendment to the amendment in the nature of a
Without
substitute.
objection, the amendment is considered as read. The gentlelady from Washington is now recognized to present her amendment.
Thank you, Mr. Chairman. Unable to pass their cruel and inhumane border bill, H.R. 2, into law, it appears that Republicans are now attempting to give state attorneys generals the authority to try and stop the Biden administration from carrying out important policy priorities by giving them standing to sue in federal court under a variety of sections in the Immigration and Nationality Act. The ranking member in the last amendment already discussed how this entire bill is likely unconstitutional and how some of the provisions in this bill are direct attempts to overturn U.S. v. Texas. This was a case where Texas tried to gut the president's policy of prioritizing DHS's limited resources on individuals who pose a public safety threat. My amendment would focus on a different section, the use of humanitarian parole. My amendment would remove the section that would give states standing to sue and attempt to block any administration's use of parole. Parole is an important humanitarian and foreign policy tool that allows individuals to enter the country more expeditiously in urgent circumstances. The power to parole people into this country has been used by the executive branch since President Eisenhower's administration by Democrats and Republicans. It has been used to parole in Cubans and Haitians during the Mariel boat lift, as well as for Filipino World War II veterans and for Hungarians fleeing communism. This administration has used parole to address a variety of crises around the world. Under the Uniting for Ukraine parole program, over 175,000 Ukrainians have been temporarily paroled into the United States as they sought safety from Russia's unprovoked war of aggression. The administration also used parole after the fall of Kabul to keep our promise to the many Afghans who aided our troops over the 20-year conflict there. And most recently, parole has been used to alleviate pressure on the southern border through the Cuba, Haiti, Venezuela, and Nicaragua parole program, which started in January 2023. All these parole programs are not unlawful, despite my colleagues' claims. While classes of individuals are invited to apply for parole under these programs, each application is adjudicated on a case-by-case basis as required by statute. Despite that, Republicans attempted to essentially end all these programs and overall decimate the broad parole power traditionally left to the executive branch in H.R. 2. Knowing that that bill is going nowhere, Republicans have now turned to the courts. Texas and 20 other states have a lawsuit pending against the Department of Homeland Security attempting to stop the administration's Cuba, Haiti, Nicaragua, and Venezuela parole program. One of the big questions in that lawsuit is whether the states have standing to sue over such a program. Clearly, my Republican colleagues are worried once again that Texas does not have standing or this provision would not be included. It's important to note how successful the CHNV parole program has been in creating what Americans want, which is an orderly process for migrants to come to the United States. No one wants to make the dangerous trek to the southern border. We have seen time and time again, when given a chance to come in an orderly way, people will choose to come through a legal pathway. And we've seen this play out in real time. In late 2022, the number of Cubans, Haitians, and Nicaraguans crossing between ports of entry was on the rise. However, since the implementation of the Cuban, Haitian, Nicaraguan, Venezuelan parole program in January of 2023, encounters of Cubans, Haitians, and Nicaraguans between ports of entry are down over 90%. We have also seen how the reverse can happen. President Donald Trump did all he could to decimate the legal immigration system. For example, when the Trump administration cut off refugee processing from the Congo, we started seeing Congolese refugees at the southern border where we had never seen them before. By attempting to end this vital parole program, my Republican colleagues are showing us once again what we have heard for this whole hearing. They are not interested in solutions. They don't want to work in a bipartisan way to address the situation at the border by fixing the underlying system, nor by giving Border Patrol the resources that it needs. Instead, they said the quiet part out loud. Donald Trump did, many Republicans on the other side did. They want to keep a broken immigration system out there as a campaign issue. They want to scapegoat and fearmonger about immigrants and immigration. Ending the ability of this administration and future administrations to use parole will create chaos and dysfunction at the border. I hope my colleagues will support my amendment, and I yield back.
Gentlelady yields back. The chair now recognizes the gentleman from Texas, Mr. Roy.
I thank the chairman. I would note that we've had a number of conversations about the legislation of the Senate. I associate myself with the remarks of the gentleman from North Carolina that the legislation from the Senate was very specifically designed to deflect by my Democratic colleagues their utter and complete failure when it comes to the border. That is precisely why that bill was done. It was done heading into an election season knowing full well that it would fail, had zero chance of success, so they could try to pass the buck. The fact is it was flawed on numerous levels. Specifically, it would have codified President Biden's failed asylum rule, which eliminates the adversary component of immigration proceedings, meaning ICE attorneys are no longer part of the process, eliminating cross-examination. Catch and release, it specifies that migrants who cannot be detained will be released and placed under the supervision of, quote, alternative detention programs. It would have codified releases, which flies directly in the face of the requirement to detain. It would have enshrined FLORAs for family units and unaccompanied alien children. The bill mandates families are released in the interior under alternatives to detention and maintains the status quo of releasing unaccompanied alien children. And by the way, those numbers didn't even apply to the outrageous caps that set the standard flow close to 5,000, which would have meant 1.8 million per year. It put lawyers in place for illegal aliens to the tune of $350 million. Parole, it would have codified and expanded the unlawful use of parole. The unlawful use, which flies in the face of what the gentlelady was just describing, because in the statute, the specific language says, in his discretion, parole in the United States temporarily under such conditions as he may prescribe only on a case-by-case basis. This whole notion of categorical parole flies directly in the face of what the statutes contemplate, literally in black letter text. And the administration ignores it. And they do so intentionally. And they do so in such a way that floods the zone, so that we end up with situations like we had 1,000 illegal aliens from Venezuela rushed and nearly breached the El Paso port of entry. We've had numerous situations constantly dealing with the border because this administration is blatantly disregarding the specific text of the law. The Senate bill would have codified this mass migration efforts by the administration. They did it intentionally. That's why the Senate Democrats wanted that.
Yep.
They did it on purpose so that my colleagues could do exactly what they're doing in this hearing, trying to deflect their failure that is causing untold damage to the American people, causing untold deaths of fentanyl poisoning to the children, including in my district, where I represent. The number of people throughout the state of Texas that are suffering as a consequence of this, the amount of money that Texans are having to spend, the extent to which DPS and our troopers are having to spend time at the border doing the job the federal government refuses to do. And very importantly, with all due respect to my colleagues on the other side of the aisle who said otherwise, the extent to which Border Patrol agents are delighted that we impede what the federal government won't do. They are so thankful, calling us specifically saying, thank you for doing that. Thank you for putting the razor wire down there. Thank you for standing up in Eagle Pass. And thank you for impeaching Mayorkas, because they're sick of it. They're sick of a secretary who lied about them, who literally knew and had a briefing specifically that there was no whipping of Haitian migrants, and yet went to the microphone and perpetuated that false trope that somehow these Hispanic, overwhelmingly Hispanic Border Patrol agents were acting racist in saying they were whipping Haitian migrants, which was clearly false based on every photo that was put forward. That is your Secretary of Homeland Security. That is the face of the Biden administration. And that is what my Democratic colleagues want to run away from, because they know it's a complete and total failure. They know that it's why the president is polling completely in the toilet, because the entire nation knows that wide open borders is endangering the American people, endangering the very migrants that my Democratic colleagues say they want to support in the false name of compassion, while they get sold into the sex trafficking trade, get abused by cartels, end up dying along the Rio Grande River, dying on ranches, while ranchers have to find dead bodies on those ranches in Texas. And then they want to come in here and say that my friend from North Carolina is somehow flawed for wanting to say we want to make sure that states have the power under the Constitution to go before a court and say they demand redress for the fact that the federal government refuses to do its job. Yes, we impeach the secretary. Yes, we should be able to go into court to enforce the laws that are put before us to make sure that our country is safe and to make sure that we can do the job that the federal government refuses to do. I yield back.
Gentleman yields back. The gentleman from Arizona withdraws his point of order, and the gentlelady from Texas is recognized. I think the order I had was this gentlelady from Texas and then that gentlelady from Texas.
Chairman, thank you. Let me rise to support the amendment by the ranking member, gentlelady of the subcommittee on immigration, and thank her for her great work. I'm not sure if we were down in Eagle Pass together or we were down, but I know that we have both been to the border many times, but in particular, we were at Eagle Pass. You know, it would be a breath of fresh air if in the passage of this legislation, Congresswoman Jayapal, I could count on the consistency of the state's attorney generals. We know one, for example, Attorney General Keith Ellison, we know him, being able to file lawsuits dealing with the separation of children from their families, or that they would file lawsuits regarding the heinousness of barbed wire, or the boys, or the conditions when these families would come and they would attempt to seek relief. And if they would file on behalf of border towns, that the border towns needed more resources. If I could say that this bill would pass and the litigation would be on the uplifting of a crisis, or the litigation would be on helping nonprofits that are struggling and are depleted of dollars, just like local cities and towns are depleted of dollars, then we might have a point of discussion. I've already argued, however, against myself because I don't believe the states have the immigration authority because it is constitutional, it is the responsibility of the federal government. But what I would say is that this amendment would protect the parole power from being subjected to lawsuits that would result from this bill. The parole power has been used by every president since Eisenhower. Parole is an important tool available under the Immigration and Nationality Act that allows certain individuals to enter the United States and temporarily stay without a visa. Parole is discretionary and granted by Department of Homeland Security in a case-by-case situation. Natural disasters, El Salvador, Guatemala, people from Afghanistan that I've been working with in my constituency on parole because of the crisis that they face. Do you want to shut that down and allow the state's attorney generals to dismember the parole capacity? Separate families. Some families have relatives that are on parole. They are statused, or they have some form of status. Historically, presidents have used parole for individuals in response to humanitarian emergencies or in furtherance of foreign policy or public interest objectives. Right now, they have expanded the opportunity for Palestinians who are here in the United States to be on expanded parole because of the crisis in the region. This is the heart of America. This is the Statute of Liberty's very essence and purpose. In 1956, President Eisenhower oversaw the parole of over 30,000 Hungarian refugees into the United States, which generated a large Hungarian-American population that we have today. Thousands of parolees followed through various administrations. And so our concern would be, and the gentlelady's concern, and rightly so, is that we don't take away a humanitarian approach to dealing with the really core of what America's about. We are a land of immigrants, and we're a land of laws. I've always said that, and I've had the privilege of being the ranking member on the Immigration Subcommittee. And I said that so that it went across all levels of the population. I don't disagree that we have laws. And I don't disagree that we don't have immigrants. And I said earlier in my debate that upwards of $1 trillion will go into the economy if we had a real system of immigration that would protect the American people and as well protect those who are fleeing. And so my good friend from Texas has rightly so embraced the Border Patrol agents. I want him to know that I embrace them, have done that now for the very moment that I've come to the United States Congress. And in fact, know generations of Border Patrol agents. That's how long. Seen people that have retired or seen people that's gotten promoted. And so you can't embrace the Border Patrol agents and want to say that they're embraced only by one party. When we actually did something against the Border Patrol agents, the Republicans did by rejecting the President's supplemental Southern Border bipartisan immigration bill that the Senate was trying to move forward. And so I believe this is a sense of irony that we have an embrace over here and we can't give them love over here. I ask my colleagues to support the Jayapal amendment and not the underlying bill.
Chair recognizes the gentlelady from Wyoming, Ms. Hageman.
Yes, very quickly. I always find it interesting that the folks on the other side of the aisle talk about the Statue of Liberty. What I'd like to point out is that the Statue of Liberty is just that, it is a statue, it is not a statute. It does not carry the force and effect of law, regardless of what may be written on the base of that beautiful statue. But we are not a nation of immigrants, we are a nation of citizens. I am not an immigrant, I am a citizen of the United States of America. And if you are going to talk about the rule of law, it must include adherence to our immigration laws and respect for our border. You cannot talk about the rule of law and at the same time allow tens of thousands and millions of people to cross into our country illegally in violation of the law. They are not the same thing. So with that, I yield back. Thank you.
Gentlelady yields. The chair recognizes the gentlelady from Texas, Ms. Escobar.
Thank you so much, Mr. Chairman. I rise to support my colleague, Representative Jayapal, and her amendment. Earlier, my Texas colleague on the other side of the aisle criticized the Senate bill, a border security bill that Senate Minority Leader Mitch McConnell called the toughest bill on the border in the history of Congress. My colleague on the other side of the aisle on this committee from Texas called it flawed on numerous levels. And yet, these same House Republicans embrace and uplift their bill, H.R. 2, as some kind of solution H.R. 2 is flawed on numerous levels. Most importantly, because fundamental to their approach to border security is a complete reliance on Mexico. They are essentially relying absolutely on Mexico to accept every single migrant that they want to expel at our southern border. That's never happened, nor will it ever happen. So their bill, H.R. 2, is a complete fantasy, and it is flawed on numerous levels. So what works? Representative Jayapal has laid out a provision that actually works. When we look over the history of multiple administrations, including the Trump administration, administrations used parole as an effective tool to create a better managed border. And so I think if what we all want, and I think all of us are united in wanting a better managed border, that is going to take Congress acting. It's going to take us doing our job. And so this amendment would help us pass legislation, do our job, in other words, in order to create better management. I also want to remark on something else my colleague from Texas mentioned about Border Patrol being grateful for the Republican strategy. I want to remind everyone that the Republican strategy so far has been basically to deny Border Patrol the resources that they need. The president asked for a supplemental bill which would have provided for thousands more Border Patrol agents, and guess what? My Republican colleagues said no. The supplemental would have provided for more OFO officers. Guess what? My colleagues said no. Resources that are badly needed on the border and beyond, my colleagues, my Republican colleagues, said no. So when we look at who actually wants to solve the challenge at hand, it is over and over and over again Democrats who want to address and solve the challenge at hand with solutions that work, with solutions that uphold our values, yes, as a nation of immigrants, because frankly, unless you are Native American, you or your ancestors came to this country as an immigrant. And so I am so ready for anyone on the other side of the aisle who actually wants to do their job. Imagine that, Congress wanting to do its job and work on bipartisan solutions. I'll also remind my colleagues on the other side of the aisle that my colleague, their colleague in the Republican conference, Maria Salazar from Miami, she and I filed a bipartisan comprehensive immigration reform bill that addresses the border and beyond. They are welcome to join those of us who actually want to fix things. Thank you, Mr. Chairman. I'll yield back.
Gentlelady yields back. The question occurs on the amendment from the gentlelady from Washington. All those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it.
Roll call, please.
Roll call being requested. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Buck? Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Sparks? Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Johnson? Mr. Schiff, Mr. Swalwell. Mr. Swalwell votes aye. Mr. Liu, Ms. Jayapal. Ms. Jayapal votes aye. Mr. Correa, Ms. Scanlon. Ms. Scanlon votes aye. Mr. Neguse, Ms. McBath. Ms. McBath votes aye. Ms. Dean. Ms. Dean votes aye. Ms. Escobar. Ms. Escobar votes aye. Ms. Ross. Ms. Ross votes aye. Ms. Bush. Mr. Ivy. Ms. Ballant. Ms. Ballant votes aye. Mr. Massey, you're not recorded. Mr. Massey votes no. Mr. Roy, you're not recorded. Mr. Roy votes no. Mr. Klein, you're not recorded. Mr. Klein votes no. Mr. Buck, you're not recorded. Mr. Buck votes no. Ms. Sparts votes no.
Clerk will report.
Mr. Chairman, there are 10 ayes and 18 noes.
The amendment is not adopted. The question is now on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
And pin the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present, the question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
Opinion of the chairs, the ayes have it.
Roll call, please.
Roll call being requested, the clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Buck? Mr. Gates? Mr. Biggs? Mr. Biggs votes yes. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Gooden? Mr. Gooden votes yes. Mr. Van Drew? Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes yes. Mr. Moran? Ms. Lee? Ms. Lee votes yes. Mr. Hunt? Mr. Fry? Mr. Fry votes yes. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson? Mr. Schiff?
Your amendment took it out of everything.
Mr. Swalwell?
Yeah, right.
Mr. Swalwell votes no. Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar? Ms. Escobar votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy?
No.
Mr. Ivy votes no. Ms. Ballant?
No.
Ms. Ballant votes no. Mr. Buck? Mr. Buck votes aye. Mr. Issa votes aye.
Anyone else wish to record their vote? Clerk will report.
Mr. Chairman, there are 19 ayes and 11 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating in all adopted amendments, and the staff is authorized to make technical and conforming changes. Just for the committee, it's the intention of the chair to move through the technical correction bills we have, and then we will adjourn and resume the markup next week when we come back, or the following week. I got to look at the schedule, because we're going to have votes on the floor here in about 15 minutes. So we have 5 technical correction bills to be considered consistent with committee practice, and without objection, the committee will consider these 5 bills en bloc. Hearing none and pursuant to notice, I call up H.R. 7326, H.R. 7324, H.R. 7341, H.R. 7339, H.R. 7316 for purposes of markup, and move favorably that the committee report these bills favorably to the House. The clerk will report the bills.
H.R. 7326,
Without
H.R.
objection, the bills will be considered as read and open for amendment at any point. The chair now recognizes himself for an opening statement. These 5 bills were submitted to the committee by the Office of Law Revision Counsel. The OLRC is a small office in the House of Representatives that is responsible for preparing and publishing the United States Code. As Congress passes laws, the code needs to be updated to incorporate these new laws and to ensure that references are correct. Providing for the maintenance of the code is the responsibility of the Judiciary Committee, and we work with OLRC to accomplish that task. The bills before us today make technical and editorial corrections to update the code and incorporate laws passed by the United States Congress. These bills do not change the meaning of any law on the books today. Our committee has historically dealt with these bills in a bipartisan manner, and that will continue this Congress. We traditionally divide these bills equally between the majority and the minority. I want to thank our Democrat colleagues for working with us to advance an uneven number of bills today. I want to thank Mr. Tiffany, Mr. Bentz, Ms. Ballin, and Ms. Ross for introducing these 5 bills before us today. I urge all members to support the bills, and I now recognize Ranking Member Nadler.
Thank you, Mr. Chairman. Mr. Chairman, one of the often overlooked and most critical responsibilities given to the Judiciary Committee is to oversee the revision and codification of the statutes of the United States. I appreciate that today we are continuing the bipartisan tradition of ensuring that the U.S. Code is current and accurate. Currently consisting of 54 titles, the Code compiles the general and permanent laws of the United States into coherent subject areas. This makes our federal laws accessible both to the government officials who work to fairly administer them and to the private citizens who seek the benefits or relief the laws provide them. Painstaking and vital work of maintaining and updating the Code falls to the expert lawyers working under the supervision of the House and the Office of Law Revision Counsel. I'm grateful to them for their hard work and for their dedication to the rule of law. The 5 bills we are considering today make a variety of technical corrections to various titles of the U.S. Code and account for legislation that has become law since certain titles have been enacted into positive law. The statutory changes made by these bills are purely technical in nature. They do not change the meaning or effect of any existing laws. They simply ensure that the Code is an authoritative, accurate, and accessible source of federal law. I want to thank the chairman for the bipartisan way in which he is taking up these bills. I appreciate the sponsors of each bill for their leadership, and I yield back the balance of my time.
Without objection, all other opening statements will be included in the record. Who seeks recognition? Reporting quorum being... Everyone's ready to go. You notice I looked directly at the gentleman from Maryland. Okay, that's great. A reporting quorum being present, the question is on favorably reporting the bills. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the bills are ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, staff is authorized to make technical and conforming changes. This concludes committee business for this meeting. The meeting is adjourned.
Perfect timing.